Session, the Honorable Michael and Lori, and the back, the
Well, good morning, everybody. On behalf of Judges Murray and Reardon, welcome. I've looked at the list. I think everybody in here has crossed swords before, so I'll not give the usual speech about how we've read everything and that. And just, we do have a busy day, so we'll jump into this. I do remind you, though, as I must, that if there's a case involving minor children, please refer to them by their initials rather than by their names. So we will begin. We're taking the first case out of order, and it's going to be remote. That is item number 5, docket number 359,739, MT versus DM. I guess this one's remote.
One's remote, one's not.
Okay, I thought it said both were, but glad to see you here.
How you doing, Mr. Gentry?
Very good, yeah.
Good to see you.
Good to see you.
Ready to begin?
Very good, Your Honors. Good morning. Kevin Gentry on behalf of the respondent. Your Honors, there are those that say that leering is a form of rape, that yelling is a form of violence, and the coercive control is a form of domestic violence. But the legislature doesn't say that. The legislature knows very well how to write a statute and have it be liberally construed. They say liberally construed. They didn't do that in the PPO statute, Your Honors. They listed specific things that had to be found. In this trial court here, on one of the weakest PPO petitions imaginable, one that focused mostly on exclusive use of the marital home in a divorce context and marital funds, found only a pattern of coercive control and anger. Well, anger, that's why they're getting divorced. As for coercive control, that's not in the statute, Your Honor. The only coercion in the statute involves animals, and they don't have any. This is about whether or not the statute is specifically applied as written, and this trial court didn't. In Washtenaw County, where the petitioner just happens to be an assistant prosecutor in charge of domestic violence, they use the term coercive control a lot. It's in the record in this case, it's in the record in the divorce case of the referee. It seems to be a thing, Your
Isn't
Honor.
that just describing conduct? I mean, the fact that the phrase is not in the statute, I mean, what difference does that make? I mean, it's describing conduct that could fit within the catch-all at a minimum.
It could if the court found that. The court didn't find that it created a likelihood of A, B, C, D, E, F, G, any of those happening. There's not that causal connection there. If there was a causal connection where the court said, okay, there's coercive control, he broke her shoe rack in Grand Rapids 3 years ago, and therefore he might break it over her head, absolutely, I wouldn't be standing here. But the court short-circuited that analysis. They didn't go the final step here, and that's a real problem. With that, I'll reserve some time for rebuttals, Your Honor, but I'll take any questions you might have, of course.
I don't have it.
Nothing.
Thank you.
Good morning, everyone. Nick Jura on behalf of the appellee petitioner. I rely upon my brief. Unless you have any questions, I'm happy to answer them, but it's all in my brief.
I don't have any questions.
I have none.
Nothing. Got
Thank you for
there.
your time,
Okay.
Your Honor.
Thank you. Good to see you.
These will be submitted. It brings us to item number 1, docket number 359491, People versus Michael James Scandalito.
Hey,
Morning.
good morning. Stephen Helton on the State Appellate Defender Office on behalf of Michael Scandalito. I'm sure the court has read our briefs, so I want to keep this short and answer any questions the court has. Today, I just mainly want to address as to issue 1, some of the prosecutor's arguments about what is and is not in the record in this case, or is and is not part of the parties' agreements, and then and also what Mr. Scandalito is arguing, and then as to offense variable 9, how McGraw actually applies to Mr. Scandalito's conviction of assault with intent to rob. So as to my first point, prosecution in their brief, they assert that that this document, with the caveat, assuming no other convictions, was part of the defense file and was provided to the defense before, at the time of the plea agreement. There's no showing of that. I don't know how the people would know what's in the defense file, but I can represent to the court that.
Wouldn't the defendant know his criminal record?
Well, that's another point that I do want to address, and I'll get back to that right now, right after I just finish this point. As to whether or not Mr. Scandalito was provided this information, there's no evidence of that. The only place in the court file where this is located is as an attachment to the prosecutor's sentencing memorandum, which occurred, of course, after the plea was entered, and in relation to this to this specific issue. As to whether Mr. Scandalito should or should not know his own convictions, I
have to agree with the trial court in that the appellant was in the best position to know his criminal history, and the Michigan Department of Corrections was probably in the second best position.
On that point, I think the people's brief strongly indicates that Mr. Scandalito is somehow to blame for whatever this is. There's no indication that Mr. Scandalito was consulted or asked to go over his convictions, and that's kind of the thing is the people, in their sentencing memorandum after this issue arose before sentencing, in the post-conviction motion and in their brief and appeal, they haven't identified a conviction that they were not aware of at the time that they entered into this agreement, that they only became aware of through the probation office. And I mean, that would obviously be very pertinent information here. And if it existed, it presumably would have been asserted. And as to whether or not Mr. Scandalito is in the best position to know what is and isn't his criminal record. I think as to whether or not certain convictions are included under certain prior record variables, these are complicated issues. I think, the case law on this specific issue kind of shows that. And I guess as to what we're arguing, there's a lot of claims in the prosecution's brief that we're arguing there's a sentencing agreement, or if the court orders specific performance in this case, prosecutors will be bound, or courts will be bound by prosecutors' agreements as to the guidelines. That's not the case. The prosecutor agreed to support this specific guideline range. There's no showing that the range was even based on this PRV. And so that's not our argument. Our argument is they can't agree to a specific guideline range and then argue against it at sentencing, because that is contrary to what the good faith interpretation of their agreement. And just as to OV9, the main case is the prosecution's brief cites to say that OV9 should count conduct that occurred after this offense was committed, predate McGraw. And obviously McGraw changed that, changed the interpretation of the sentencing offense. And I think I would still agree with the people that OV9 could be counted for the cousin if Mr. Scandalito's conviction were robbery, but it's not. It's assault with intent to rob, which encompasses less conduct than assault with intent to rob, which does not include actions that occur while attempting to flee the scene of the crime. And so, unless the court has any specific questions, I'll save the remainder of my time for a minute or two of rebuttal. Thanks.
Good morning. May it please the court, Melissa Keys on behalf of the people. Your Honor, looking at the record at the plea taking, looking at the sentencing memorandum that was submitted by the defendant in this case, looking at the statements made by the defendant and his defense counsel at the time of sentencing, looking at the fact that there was no affidavit provided in support of the defendant's motion, I don't see how this court could ever tie the hands of the prosecutor's office or the trial court when considering the context by which this agreement was reached. Here, the parties anticipated in good faith what the scoring would be that was communicated to the defense counsel as is customary during plea negotiations. We frequently try to determine what a person's offense variables or prior record variables might be, with the understanding that they might change. And ultimately, it is the sentencing court's determination as to how to score variables. I think that the plea taking court did an exemplary job explaining to the defendant, who is not new to the system, that even though the parties might believe in good faith that there is this range, certainly she also indicated that and made sure the defendant understood that nothing was being promised to him. And I think that the defense's attempt now to try and say, well, we don't want to have his plea withdrawn, right? Because the plea benefit that the defendant got is obvious. He was facing a mandatory minimum of 25 years as a violent habitual. He was on parole at the time, so he did obtain a substantial benefit. And indeed, the sentencing court sentenced him to a within guidelines range as the parties believed it might be. and as what it ultimately turned out to be. The court did not sentence the defendant to the very lowest end of the guidelines. It was towards the lower end, but certainly not the lower end to where the defense could then argue, well, if it would have been lower, perhaps the defense or perhaps the trial court would have sentenced him to something that was 126 months. Certainly that was not the case. Also, there was no affidavit provided to indicate that the defendant was solely relying on this promise by the prosecutor, because there is no promise, and certainly to hold otherwise would significantly impact plea bargaining in the future, because it's getting to a point now where we just can't, we end up before your honors, no matter what happens. If a defense attorney doesn't try to anticipate what guidelines are, he's ineffective. If we try to negotiate as parties, now they want to enforce an agreement when there are criminal convictions, and here there were a number of criminal convictions that the defendant had, and that's just not promoting fairness. And even though I know that the defense looked at contract principles, but which you have to look at the terms of contract principles, but they have to serve the interests of justice, and to hold or to rule in a way that the appellate defender's office would like you to rule certainly would not be promoting the ends of justice in this particular case. And secondly, to briefly address OV9, I believe that the defense is mischaracterizing the position of the parties and what was happening at the time that Ms. Burley was being threatened with a kitchen knife.
Scissors.
Sorry, the scissors. That's correct.
In the kitchen.
In the kitchen. That's correct.
Cousin tackles him while that's going on, right?
Right. Yes.
Okay.
Because even when he's trying to say to him, "Hey, I'll give you my car keys," he was not deterred. He didn't say, "Oh, okay, that's great." He continued holding his grandmother by the throat until Mr. Burley tackled him to try and get the scissors away from the defendant. So certainly that is in line with McGraw, and the scoring as it relates to OV9 should be affirmed. The defendant's convictions, his sentence, and the rulings by the court should all be affirmed. And the council did not address PRV2, so I'm not going to address it unless the court has any questions. I'd be happy to address them.
Any questions? You have some rebuttal, Mr.?
Thank you.
Thank you.
Okay, thank you.
Just a couple moments briefly. I'm not sure what sort of affidavit we would need to submit in this case as our offer of proof. Our claims are made on the record, and our request for specific performance, it doesn't require defendants to establish reliance. It's just an interpretation of the meaning of the parties' agreement and whether or not that was abided by. This term regarding the guidelines, it plainly was a part of the parties' agreement. It's not as though the present court rule, which I don't believe was in place at the time of Mr. Scandalito's plea, where the court informs the defense that preliminarily we believe your guideline range will be this. That wasn't what it was, and we know that's not what it was, because the guidelines weren't mentioned as just this is what we anticipate. The defense said this is part of the plea agreement, and the trial prosecutor got on the phone and called the other prosecutor who had made this agreement and confirmed that this was an aspect of the parties' agreement. So if it is a part of the parties' agreement, and I think it clearly is from what's stated on the record, then it has to mean something. And I do believe that the people's argument is that it simply means nothing. And I think that actually would in fact impede plea negotiations. And just finally, regarding the substantial benefit Mr. Scandalito received, we agree. We don't dispute that even if you remove this aspect, the sentencing guideline aspect of the agreement, that Mr. Scandalito's plea would otherwise be illusory or something of that nature. We just think he's entitled to what he bargained for, and that he should receive it. And no, we don't believe that the trial court would be bound by the parties scoring, but I think the court can look at the record and see that the trial court is not investigating the proper scoring of the guidelines when the parties are in agreement on a particular range, as established by the court scoring of each guideline that the parties did not dispute. So unless the court has any other questions, we would just ask.
Just backing up to that OV9, do you disagree with those facts that?
In terms of that, how the offense, I don't disagree with the description of how the offense of what occurred physically, what, the factual basis of the plea. What I think I would urge the court to look at are the elements of assault with intent to rob. Assault is the elements are to put in fear of an immediate battery or unwanted conduct with the intent to use force or coercion to obtain property or to commit a larceny. And I think that assault was committed when he put the scissors to his grandmother's neck and demanded her car keys. Whether or not, I think, the fact that there are scissors, certainly the cousin was in danger potentially at some point during the scrum or the altercation, but the cousin is obviously not in danger when the scissor blades are directed at the grandmother, by the time that they're anywhere else, the assault with intent to rob has been complete, and it is no longer being committed, and under McGraw can't be scored. And so that's our position, and we hope the court adopts it. Thank you.
Thank you. Case will be submitted. Brings us to item number 2, docket number 360015, People versus Ronald Lewis Kennedy.
Good morning, Your Honors. Michael Front on behalf of Mr. Kennedy. Court has, very lengthy briefs in front of it, and at the same time, there's really not that, in a sense, there's not that much going on in this case because I've tried to acknowledge we're seeking changes in law. I think I used the phrase change in law and law reform more in this brief than I have the previous 50 briefs I filed. That's certainly true of issues 1 through 3. And there's changes this court can't provide it. I think the court knows that we have to present the issues to this court if Mr. Kennedy wants to continue his appeal to the Michigan Supreme Court, see if they'll look at, especially that issue 2, I think is something they may be interested in. So I kind of regret presenting really lengthy briefs to this court on issues that the court really has to deny me on. But I think the court knows that's why I'm doing that. And the fourth issue is fairly complicated. They do have a waiver argument. I've tried to work through that. I won't try to unpack that today. I think the argument I made, I'll just stand on my brief unless the court has anything it wants me to address.
Morning, Your Honors. Assistant Prosecutor Danielle Walton from the Old County Prosecutor's Office, representing the plaintiff appellee, the people of the state of Michigan. I just briefly want to talk about issue 1 because defendant in his brief asked that this court hold the case in abeyance pending Posey. We would alternatively argue that this court affirm based on Posey, especially since this issue has been up to the Supreme Court in Ames previously and they denied leave and there's not a full leave grant on Posey. Or alternatively, this court could find, regardless and setting aside Posey in the statute, that defendant's guideline sentence is a proportionate sentence. Defendant wants the court to adopt Milborn, both in this court and the lower court. The Milborn states that even sentences within the guidelines in unusual circumstances are disproportionate. This case just does not present that unusual circumstance. It's egregious offense and defendant has a really severe history of felonies as well as his history of battering his partners. But if this court has any further questions, I'd be happy to answer them. Thank you, Your
both
Honors.
very much. That case will be submitted. Brings us to item number 3, docket number 362,271, Mother Injustice against the Attorney General.
Judge Kelly, before we begin, can I say something?
Yes. And
You know, I'm assuming it was this case because I received an unsolicited phone call last week. No party, no affiliation was mentioned. And I'm assuming it was this case, and I shut the person down as soon as he started talking of anything that I thought might have been substantive. Told him that I could not discuss the case. There was no substantive discussion. But I'm bringing this up to please warn anyone that might be affiliated with either any of the parties here, any of the amicus briefs or anything, not to contact the court directly. Okay? It was
Okay.
quite unnerving to get a phone call like that.
Okay. Good morning.
Morning.
Eric Restusha, appearing on behalf of the state of Michigan. With me at council table is John Hirsch, who is the attorney for the legislature. We're splitting our time. I've ceded 10 minutes of my time to Mr. Hirsch for the legislature. A couple of housekeeping matters. One is that however this court rules, the state of Michigan would ask that the court publish its decision, and that also they would issue a decision before February 1st. I'm sure the court's aware of the deadline of February 19th. And also if the court.
Are we bound by that deadline?
No, you're not.
I didn't think so.
No, you're not. But
That's a lower court that made the deadline, correct?
True, that's right. But I obviously there are a lot of other stakeholders who are using that date. So it has it's a consequential
Isn't the
date.
date February 18th or is it the 19th?
It's the language of the order for the stay was through February 19th was the language. So February 19th, we're using that as a date. So we've asked February 1st, and of course, this doesn't bind the court, but we've asked that February 1st be the date by which this court issues a decision. And if it reverses the Court of Claims decision, the state would also ask that the court give its decision immediate effect only to avoid any ambiguity about the ongoing role that the February 19th date would play. So obviously this has gotten attention in the community itself, and we want to make sure that just clarity for all of the stakeholders. One last housekeeping matter is that I caught a mistake last night in looking at my brief. On page 38 of the principal brief and page 11 of the reply, I had quoted from In Re Advisory Opinion 1982 Public Act 47 for the proposition that the right remedy is another initiative or next election. I should have noted that it was quoting an Idaho case, Luker versus Curtis, Luker, which is 64 Idaho 703. I just want to make sure the court's aware of that. All my pencils have erasers. So, all right, with that, I have 3 points I'd like to make this morning. I know the court's read this and is very familiar, but given the importance of the case, I'd like to kind of walk through it a bit. So here are the 3 points I'd like to make. The first is that the Constitution is unambiguous, that it does not limit the legislature's authority to adopt an amendment and enactment within the same legislative session, consistent with both Article 2 and Article 4. That's supported by the case law and by the constitutional debate. The second point is that this constitutional framework is a sensible one and has a rational basis for it because there may be a need to correct a legislative enactment within the same legislative session. Even Judge Shapiro, who ruled against us, recognized this in page 24 of his opinion. Note 8, he kind of reserved that question if there was an emergency or other changed circumstance. And it's the state's position that if there is that authority based on an emergency or a changed circumstance, that ultimately the question of whether that was the basis for the amendment is outside of the court's review ultimately, whether it's in good faith or based on an intervening emergency, consistent with the analysis of this court in Reynolds. In fact, Judge Shapiro, I think, was trying to avoid the application of Reynolds by saying it was over a dictum and maybe had been superseded. But in my view, this court is bound by that post-November 1990 decision. It doesn't answer this question, but it's analogously relevant on the question about the court's authority to determine whether there was a need for a change or not. And the third point I'd like to make this morning relates to a couple of the errors that underlied the Court of Claims decision below. One being looking at the three options that are available during this 40 session days that the court assumed that or relied on those limitations extending beyond the 40 session days, and they do not. They are anchored within the 40 session days, both textually and in the structure of the Constitution. And the second kind of mistake is misunderstanding the phrase subject to referendum. An act that has been amended, the original act in its pre-amended form can be subject to referendum. And that's the purpose of the citation to the unpublished case.
Neither one of them had immediate effect anyway, right? So
Neither did.
You
That's
got
right.
the 90 days for the referendum, it all matches up.
Yeah, so there could have been a referendum on the original act before its amendment, and that's consequential because, of course, if you look at the analysis from this court in Reynolds, it talked and cited this McBride case, an Arizona case, and said essentially, if you have a referendum that's on an act prior in time, but then it's approved by the voters, the implication is that's when it's enacted and would supersede anything in conflict. So, all right, so those are the 3 points I'm going to make, but I'm going to kind of walk through it just a bit more slowly. And obviously, I'm going to be conscious of my
You're
time.
very slow for yourself.
I know,
You're
I'm
usually on much higher speed.
I've been working on that, Your Honor. It's a function of
I
age.
have a question, though.
Sure.
I think the point you said about, I think referendum is not an issue. It's not really being thwarted by what the legislature did, but what do you answer with respect to the idea that the legislature basically pulled a fast one here and by adopting it, avoided a vote of the people, which if it passed would have been then subject to the supermajority rule?
Right, I think that the kind of Reynolds talked about this in an analogous way, right? So Reynolds had the posture in which there's a referendum. Now, this is the referendum analysis, but I think the analysis is relevant for the initiative. There was a referendum, and so it suspends the law that's subject to referendum. Well, the legislature then reenacted the virtually identical law. And the answer of Reynolds was, well, the legislature can step into that space and pass laws during the referendum. And of course, then when it rejected the referendum, the reenacted law remained in place. And the question was, well, doesn't that kind of subvert the whole referendum process? And the answer of Reynolds kind of walked through this and talked about how that actually provides information to the legislature itself, even if it doesn't affect the reenacted law. Well, by the same token here, it seems to me that if the legislature has both adopted law and then amended it, and for the very thing you said, well, doesn't that take away the people's ability to have the initiative then on the ballot? But the answer is there may be a need for a change. And if there wasn't a need for a change, there still is the opportunity to have a referendum on that identical law. And then if it's passed or approved by the people, that would then supersede the amended law. So, but I think the key is, I think you have to start with really the legislative authority. And I think that's part of the mistake underlying as well, is that in the face of silence, the court thought, well, the legislature's authority is without an ability to act in this arena. But I mean, the language from Coalition of State Employees Unions is that the legislative authority of the state can do anything which is not prohibited from doing. Strongest possible statement about legislative authority. And it's unambiguous. Article 4 applies to Article 2. That's the Fry decision talking about the immediate effect. And in fact, this argument that somehow 4 doesn't apply to 2 was expressly rejected. So we know that 4 and 2 remain in place. So there has to be an express limitation on the legislative ability to amend the law once enacted. And if you look at paragraph 5 of Article 2, Section 9, it's where the limitations are created, because 3 and 4 provide the 3 options: enact without change, reject, or propose an alternative. That's within the 40 session days. That's in paragraphs 3 and 4. And then paragraph 5 describes what the limitations are. If the initiative is adopted by the people, there's then a 3/4 requirement for any amendment. If it's a referendum that approves a law, it can be amended in any subsequent session. There's no limitation identified for a legislative enactment. And there's some case law that talks about how all legislative enactments are on equal footing, on the same plane. That's from the in-rate proposals D&H, and Fry had this language about equal footing, as did this in-rate Public Act 47 for 1982 case as well, this equal footing concept. So if you also look at the constitutional debate about this very point, you have this analysis from Delegate Kuhn. He's describing to Wagner about how this law operates. And he says, if the legislature sees fit to adopt the petition of the initiative as being sent out, if the legislature in their wisdom feels it looks like it's going to be good and they adopt it in toto, they have full control. They can amend it and do anything they see fit. The suggestion has been that that language isn't really addressing the kind of question that we have in play here. And it doesn't expressly address it. I think that's true. But he had in mind, Kuhn had in mind, even the issue of timing, because at the part of the constitutional debate, it was Dean Hutchison who had then allowed an amendment for 3/4 vote if a petition were adopted by the people. Because before, a petition that was adopted by the people couldn't be amended by the legislature at all. So he allowed it a 3/4 requirement. And then Kuhn had come in and said, well, hey, I have an idea for this 3/4 requirement. Let's also say next legislative session. And Hutchinson said, no, that's okay. The 3/4 requirement is sufficient. I mean, that was just a few minutes later after he made this comment about they have full control, they can amend it, they can do anything they see fit.
We even need to consider that. I'm reading the lower court opinion that's contained in the spirit and history of Article 2, Section 9. And I'm not sure what spirit and history is. I mean, the lower courts definitely has an opinion as to what spirit and history is. Don't we, hang our hats, or shouldn't we hang our hats on the words of the Constitution? I
think it's exactly right. And I believe that's a friendly question, Your Honor. I think that ultimately I make this argument as just kind of a.
I won't be so friendly in a little.
No, that's right. But I think that question itself is. I think that ultimately the constitutional debate is not necessary. I think the text itself is unambiguous and doesn't require further analysis within the Constitution. I don't think you have to go to the Con to kind of discern meaning. I think the text, that's the common understanding. The common understanding is you start with what the people enacted in 1963 in this Constitution. And I think it is unambiguous by itself, without doing any further analysis, that the legislature can both enact a law and then amend it at the point at which it sees fit. And I think that's really the long and the short of it is. And of course, there's some analysis that talks about, in a different setting, about why there may be a need for a change. And that comes from the In-Ray advisory opinion. It talked about this very dynamic that this is talking about Article 9, Section 15, which is the borrowing statute. If the legislature wants to borrow money, it has to have approval from the people. And the Michigan Supreme Court, in an advisory opinion, was examining just kind of the referendum and opinion process and amendments to it. And it kind of talked about this very thing. The courts have reasoned that experience after the enactment of voter-approved legislation might indicate that legislation was not workable, and that in providing for the initiative and referendum, the people intended the legislature possess the power to make needed changes, as otherwise there would be no means of doing so before the next election. So this concept that somehow there may be a need during the same legislative session, it's been really considered by the court in a different setting. Again, I think that's just analogously relevant, but that concept is present. So I think if you read the text itself, it's unambiguous that the legislature could come into that space and amend. And really, the end, I think then the question comes is, what's the remedy? And the remedy is, I think this language quoted from this Idaho case is right. People, where the legislature amends an initiative act, the people have at least two remedies. They may reenact the measures by another initiative, or at the same time, at the same election, may elect other members of the legislature. Throw the bums out, that kind of concept. So that's what the court has described, in other settings, but I think that's the right analysis here, that if you don't like what the legislature did, you should perhaps subject it to referendum, vote in new legislators. And one last point I think I'd like to make, and I'm not sure if I'm cutting into Mr. Hirsch's time. My watch broke, so I'm not sure I'm doing on time.
No, you still got.
Okay, because I still want a couple minutes for rebuttal. And that's that there's been this claim that somehow what the legislature did subverted the role of the people. But ultimately, the remedy that the other side says the Constitution provides, which it does not, is that it should happen at the next legislative session. And if you look at the timing here, it was December 13th of 2018 when these Public Acts 368 and 369 were then amended. They came in amending the prior Public Acts. Well, the question is, what's okay, what's not okay in December 13th would have been okay on January 1st. It doesn't make sense to me. Ultimately, No, but seems to me the real point is if you were going to write in a fix, if the sense is that the legislature shouldn't be able to do this, the real fix would be not that, it would be a 3/4 requirement. Because if the sense is that the people were going to adopt this and the legislature didn't want people to have a vote on it, well, the limitation on the legislature should then be a 3/4 requirement, not next legislative session. Why does it matter whether it's December 1st or January 1st? But that's neither
It
here
would
nor
only
there.
matter if it was a passed by referendum,
That's right.
because it explicitly says that. And it doesn't say that for initiatives. So how in the world can you say it just?
Yeah, I think that's exactly.
Contrary to what the Constitution says.
I think the Constitution is clear. I don't think you need to go to the Concom. I think ask the court reverse and give its decision immediate effect.
Good morning, Your Honors. John Bursch on behalf of amici, the Senate and the House. May it please the court. Judge Reardon, I want to start with your question, whether we're focusing on the words or the spirit and history. And of course, it has to be on the words, or otherwise the judiciary is completely unbound to do whatever it wants. And if we look at the words, it's very clear what the outcome has to be here. First, it's undisputed among all the parties and the Court of Claims that the legislature can amend an initiated law that it enacts. The only question is if there's any temporal limit on that power to amend. And so the ordinary rule, which Mr. Restuccia discussed, this is Article 4, Section 1. This is Taxpayers of Michigan Against Casinos. This is Young versus Ann Arbor. The legislature can do anything that the Constitution does not prohibit. So we look to Article 2, Section 9 to see if there are any temporal limits, and there are only two. The first is that they have to enact or reject a law proposed by initiative within 40 session days, and it's acknowledged that that was satisfied here. And the second is that the legislature can only amend referendum laws approved by the people at a subsequent session. So there's no temporal limit at all for amending initiative laws that the legislature has enacted. And you can just stop right there.
I'm going back to the spirit and history section of the lower court opinion, but he cited two attorney general opinions. One that Governor Milliken asked for from Attorney General Kelly, I believe it was.
Mhm.
And the second one was asked by the Senate, I think, wasn't it? Or the legislature asked.
Yes.
Aren't attorney general opinions binding?
They are binding on the executive
They're not
branch,
binding on
but they are
us.
not binding on the judiciary, correct? And so, I mean, you can take those for the persuasive value, but nothing more than that.
But how about are they binding on the legislature?
We have always understood attorney general opinions to be binding on the legislature.
Right, so they violated the attorney
Is there a
general.
law that says that?
There's no law, there's no case. That's been the unwritten assumption of the Attorney General's office for many decades, including the time that I was there. I believe that's still the assumption today.
So
Assumption or just a tradition?
I think it's a tradition.
So if we're to follow that tradition, the legislature was bound by Attorney General Kelly's Attorney General opinion. Of course, that was first in time. Attorney General Schuette's was much later, as the lower court said, it gave more credence to Attorney General Kelly because it was closer in time.
Right, and of course, that could have possibly set up a debate between the legislature and the Attorney General's office as to whether the legislature was in fact bound. But that conflict never came to fruition because they requested a new Attorney General opinion, and Attorney General Schuette issued the contrary opinion that affirmed that what the legislature did was consistent with the plain language of the Constitution. Again, that's an inter-executive debate that this court doesn't need to get involved in.
Except that Attorney General opinions have that binding nature, as you talk about. Shouldn't the court be deciding what statutes mean and constitutions mean?
Well, of course it should, which is why.
The attorney, the court should be doing that, not the Attorney General's office.
Of course, the court has the final say, but not every debate about the constitutionality of a legislative or executive branch act necessarily makes its way to the court. So as Judge Kelly said, there's been this assumption or tradition that the Attorney General's opinions control the executive branch, control the legislature. But ultimately, when the dispute comes to this court is the ultimate arbiter of what the Constitution says and does not say. And to get back to your point about the text, because Article 4, Section 1 gives the legislature plenary authority to amend anything once it becomes law. That includes an initiative. We look for a restriction, and there isn't one here. And even the Attorney General's brief admits that on page 18. They say there is no explicit constitutional language prohibiting what the legislature did, which is first adopting, and then with the governor's help, with a signature, than amending. The only other point I want to make on that is that the drafters and ratifiers of the 1963 Constitution obviously knew how to put a temporal limitation on acts of the legislature in this context, because they did that with respect to the referendum laws approved by the people. And so the fact that they did it in that context and didn't here under Hamel and other precedents of this court should be construed as meaningful, that the absence of that language was intentional. The other point that I wanted to address was Judge Murray's, and his question to Mr. Restuccia, was about whether the legislature was pulling a fast one. And I want to push back strongly on any suggestion that that's what the legislature was doing. After all, when you have initiative petition, all that demonstrates is that 8% of the people wish to have a question on the ballot. It doesn't show that the people, even the people who signed the petition, would have wanted that enacted into law. And I think it's significant that Governor Whitmer, even today, within the last month, has said that this law should be amended because it would be disastrous for the restaurant industry and other aspects of the economy.
Well, we don't need to get into the political aspects of things.
Well, just in response to this idea of thwarting, the legislature always acts in the people's will, whatever it is that they want. And if they don't do that, then they're voted out of office. And so I think it
happens, doesn't it?
It does happen.
Yeah.
And so I don't think it's right to say that anything was thwarted here. In fact, the legislature enacted the power that it had. And if anything,
Well,
the fact.
Mr. Restuccia talked about the need to amend. I mean, do we examine the merit of the need? I mean,
No, you
is
shouldn't.
the need that they just don't like it and they have a majority? Is that enough to say that there was a need to amend it?
Yeah, there is no need requirement in the Constitution. If the legislature thinks that's what's best for the state is to amend, then it can amend, full stop. And there are no other prohibitions on that. Interestingly, the Court of Claims judge, in his opinion, at page 9, in his judicially created no amendment within the same session rule, allowed that there could be insignificant changes. Well, there's no textual hook for that, just like there's no textual hook for the attorney general's or the plaintiff's position, that there are some other rules here. And so briefly to summarize what the playing field looks like and where the plain language leaves us, all sides agree that the legislature can amend the initiative. The only question is when the legislature can do that. One choice is that they could never amend, and no party is arguing for that. The text isn't consistent with that. And then if you look through the parties' briefs and the amici briefs, I see the following choices. It could be you can amend in the next session, 90 days into the next session, after the new law goes into effect, at any time other than in lame duck or the legislature's position, you can always amend. And those first four choices, none of them have any textual hook in the Constitution. They're all made up. Just like when this case was before the Michigan Supreme Court the previous time, they didn't decide it because they decided they didn't want to issue an advisory opinion. The then Michigan Solicitor General said, well, the exception is if they thwart, there's that word, Judge Kelly, that if the legislature thwarts the will of the people. Well, none of the 7 justices could find any thwarting language in the Constitution to prohibit an amendment. So the only thing that's consistent with the text is the position that the state of Michigan and the legislature take, which is that once the law has been adopted, it's just like any other plain vanilla law, and it can be amended by the legislature at any time. And unless you have any further questions, I think this is fairly straightforward. Thank you.
Nothing.
Morning, Your Honors.
Are you splitting your time?
Yes,
Okay.
Ann Sherman, Deputy Solicitor General, on behalf of Attorney General Dana Nessel. I am splitting my time. At council table with me is Mark Brewer, Plaintiff's Counsel. We're splitting our time evenly.
Oh, no, Mr. Brewer.
Well, I know Ms. Sherman.
Good morning. The sovereignty is in the people, and Article 2, Section 9 is all about safeguards for the people's reserved powers. Because the people took great care to restrict and to define the legislature's limited role in direct democracy.
Yeah, but Ms. Sherman, if anybody, and that's basically the test for reading a constitution, right? Is what would a everyday person think when they read it? And they pick up Article 2, Section 9, and it explicitly says for initiative or for referendums, the legislature can't amend until the next legislative session. And then it doesn't say that about initiative petitions. Wouldn't any reasonable person read that and say, okay, you can't do it for referendums, but you can do it for initiatives? I mean, it's the only logical conclusion.
I disagree, Your Honor, because
How?
there's other language. We're looking at the text, we're focusing on the words. And if with respect to initiative and particularly with respect to the question here, the people spoke in two ways with respect to the language. They said, first, the legislature to whom that petition is going to be presented, not another legislature down the road, that particular legislature sitting, looking at that petition from point A to point B, the legislative session, that legislature had a choice. If it wanted to, it was considering the petition, it wanted to amend, it could take its version and it could put it up against the people for a vote at the electorate. And that method of how it had to respond.
All right, I understand that, but here's the problem. What did Judge Shapiro say, the rule that the Constitution provides for? Does he say that it can never be amended?
No, and in
Right,
fact,
what did he say? It has to be after the 90 days for a referendum, right?
yes, and nothing in Article 2, Section 9 restricts a future legislation. So the next legislature it has full authority to amend. Its power to amend remains undisturbed.
So in other words, then why did they have to say for the referendum that they can't do it until the next legislative session? But they didn't need to say it, but yet that's still the rule for initiatives. That's not how,
because
that's not how we interpret things.
They didn't have to say it, because when they gave a specific instruction that if this legislature sitting here looking at this petition wanted to amend, here's how they had to do it. They had to put their own countermeasure up against the people. Once they had said that, talk to that particular legislature sitting in that time, that was an instruction about what the people wanted. And the 40-day window says that's the time the legislature has to decide. It can't sit on it. It can't thwart the people's will by sitting on the decision. But that rubric of how the legislature sitting looking at that petition has to respond, that rubric doesn't end in 40 days. That 40-day window is just a period of time to decide. The people decided how they wanted that legislature to handle an amendment. And when you look at that,
all those options, once it's submitted to the legislature, they have the 40 days to act, right? Because that's what they wanted. They didn't want them to just sit back and do nothing. What then says, once those 40 days are over, that it just doesn't go as the state argues, it just goes back to being as they call it, a vanilla law that can be just amended.
with all due respect, Your Honor, I believe that is looking at the constitutional language the way we might look at a statute. Well, if they didn't say it explicitly, they didn't mean it because they said it here. When we look at constitutional language, we look at what the people would have understood. And the people understood when they gave a specific direction about how this legislature had to decide how it was going to amend. They didn't understand, they wouldn't have understood that on some magical 41st day after the window to decide, the legislature could turn around and undo and completely circumvent the specific method they set forth for amendment.
The writers of the Constitution didn't understand that, so we should make it clear now and add into the Constitution.
I don't think we're adding anything in, Your Honor, with all due respect. I think when you look at those three.
We're filling in a gap.
I wouldn't say that there's a gap, but I would say if there's any doubt in this legislature's mind.
Did. I mean, they went to the history and spirits to fill in some gaps.
I think if this court believes there's a gap, and I don't believe there is because of two things, because of the three specific options, and particularly the instructions about amendment, and also the fact that the referendum provision is in there. If, as the state and the legislature argue, this is just a vanilla law and any law is on equal footing at all times in all manners, including a legislatively adopted petition. If that were true, they wouldn't need to have included that referendum language. I mean, that would be just that would be redundant because everybody knows that a law can be subject to referendum. That referendum language in this context with the three options means something. And what it means is timing. It means that the legislature, that particular legislature can't adopt and turn around and amend. And that I don't believe is just a gap in the people's thinking. I think when we look at what that meant, what the people thought that meant, the people would have been surprised to find now that there's a suggestion that somehow on the 41st day, the legislature couldn't do what it could do on the 40th day.
Well,
But
they
if-
may be surprised. A lot of them are probably not around anymore, but I mean, it was up to them to include that language and not for us to surmise what they may have thought back in 1965.
Yeah, and if I could tag on to that, I mean, I thought we just, in your argument is that the purpose of the 40 days, which I think dates before the 1963 Constitution, was to make sure that when the people wanted something dealt with by the legislature, they needed to deal with it. So they have that. And so after the 40 days, why wouldn't the people adopting the think, okay, absent any other restrictions, they've acted and we'll see what they do.
Because those three options without any kind of fourth option, the inclusion of the referendum period that would have to run, that shows that the people intended that this legislature sitting, the legislature that was making the decision and was going to be accountable to the people, that legislature had a choice. If it wanted to amend, it puts its countermeasure up against the people's. Looking at it and what we said on page 18 is not that there's nothing in the Constitution that indicates the people's intent that adopt and amend is prohibited. What we said is that nothing expressly says the legislature cannot do this until the next session. But it does say it, because people said that the very same intent in the three options and in the referendum provision. When you put those two things together, it's clear that the legislature meant that the people meant for this legislature sitting and looking at this petition to either accept it or to change it. And if it was going to change it, it had to put it up against the vote of the people. And to look at it for whatever language the court might want to see that isn't there, and to ignore those three options and the inclusion of the referendum provision is a way of looking at this that doesn't look to the people's intent, but looks to the way we might look at statutory language, and that it's different. And that's exactly why the people said it's true in Farm Bureau. The Constitution didn't say exactly what the timing would have to be for referendum. Because they didn't say it, we can assume any way we want. No, the court looked and said, what would have been the people's intent? What would honor the people's intent? And here, what would honor the people's intent is that adopt and amend is prohibited. And that's why Farm View is the most key case on point here. That's why contemporaneous with Article 2, Section 9, Attorney General Frank Kelly said it would violate the letter of the law to adopt and amend. Now, the court, the state has a couple arguments against that. They say, first of all, that this practical argument that the legislature has this right and has to have the right to amend any law to correct things that might have to respond to change circumstances. But they have the same prohibition with a law that's accepted by the people by referendum. That's what the people decided. The people had a rubric for initiative petitions, for adopted petitions that was different, and they had a rubric for laws accepted by referendum that was different. Each put a restriction on the legislature, and there are remedies. The legislature can consider timing. They know when they can't amend during the same session that they might have to do something different than adopt in full. They can also not give the law immediate effect. That law is subject to referendum We know that from the text. And also they can amend early in the next session. There are remedies for this.
Did Judge Shapiro say that the original public acts, I can't remember what numbers they are, but the two that were the initiated laws, that after the 40 days, between the end of the 40 days and the 90 days for referendum and the sine die, the legislature can't touch those at all for any reason?
Yes. Yes.
He didn't say anything about small administrative changes are okay?
Well, he used the language, substantial changes. I don't see that in the language of the people. The people said, if the legislature wants to amend, and I read that as any kind of change. So although I do think he was correct in his ultimate ruling that adopt and amend is unconstitutional and that Public Acts 368 and 369 are therefore unconstitutional, I don't see anything in the actual constitutional language that would separate a small change from a substantial change. The people said, if the legislature wants to make a change, if they want to amend, here's how they have to do it. They have to put it up. This legislature has to put it up for a vote with the people.
I know the lower court made clear that there was a substantial change, especially in its analysis near the end of its opinion. So we're gonna, I guess if we rule the way that you're arguing for, we would leave it open as to define what is a substantial change.
The court could. It's not necessary you can affirm the Court of Claims decision.
I guess a substantial change would be something that we'll know it when we see it, kind of thing.
Well, I think a future court could decide that there is a Scrivener's error, for example, and that was not encompassed by the people's desire that.
Should we include a list of things that are not substantial changes?
I'm sorry?
Should we include a list of things that we may think are not substantial changes?
Well, my position would be there couldn't be a change at all. The people said if the legislature wants to make a change, they know how to do it.
But
Here's the
lower court seems to
instruction.
leave it open if it's not a substantial change. If we affirm the lower court, I think it'd be incumbent on us to determine what a substantial change is and what is not a substantial change.
Well, this court could affirm the basic holding that adopt and amend is unconstitutional, and that Public Acts 368 and 369 are unconstitutional without having to necessarily rule on or affirm the idea of a substantial change versus an insubstantial change and what that is. And frankly, that is an issue that hasn't even been briefed here before this court. I don't want to, I'm respectful of my Mr. Brewer's time. So if there are no further questions, the Attorney General asked this court to affirm the Court of Claims holding that adopt and amend is unconstitutional and that Public Acts 368 and 369 are therefore unconstitutional. Thank you, Your Honors.
Thank you very much.
Good morning. May it please the court, Mark Brewer of Goodman Acker on behalf of the plaintiffs appellees. First, let me indicate that we agree with Mr. Rasucha's procedural requests that he made of the court this morning, that you publish the decision. I frankly expect that whatever decision you make, we will end up in front of the Michigan Supreme Court, obviously at their discretion in terms of whether they take the case. So we agree with that. But that is unfortunately the end of our agreements with the state of Michigan. I think,
it's interesting, just as a side note, when reading all these cases that go back into the 70s and 80s, all four of your names are on all these cases. So you've all been doing this a heck of a long time. And so,
yes, Your Honor,
yeah.
as has many of you. You've been involved in a number of matters in this area of the law for a long time. So let me try to jointly address the questions I've heard this morning from Judge Murray and Judge Reardon, and not engage in a lengthy oral argument, reading material that you've already read. I think the fundamental difference here in the approach of the parties is that we constantly hear from the state of Michigan and the legislature that they have plenary authority. They are arguing this case like it arises under Article 4 of the Constitution, and the case law they cite all arises under Article 4 or another article that gives the legislature authority. This is not an Article 4 case. This is, as the Michigan Supreme Court held earlier this year in the League of Women Voters case, this arises under Article 2. And the court was very clear in that case that Article 2 is a reservation of legislative power back to the people. And so we're in a situation here where the legislature does not have authority unless it's prohibited. Under Article 2, it has only that authority that the people, in writing the constitutional provision and adopting it, gave to the legislature. So if you look at the examples that you've given, Judge Murray, this morning, those are grants of authority to the legislature. That's all they are. And that's consistent with the structure of Article 2.
So it's an all-inclusive list and nothing else.
The grants that are here, yes. And so we would agree from that perspective that you do engage, of course, in a textual analysis. And the only three options that the legislature has to be exercised in that 40-day window are adopt it, let it go to the people, or put an alternative on the ballot.
Is there limiting language in there? Something like the legislature only can do these three things?
That's not necessary, Your Honor, because the whole structure of Article 2 is as a grant of power back to the legislature. You start with the reservation of power to the people, and then everything else that you find is a grant. And if it's not granted to the legislature, it's not allowed. Now, we've heard a lot this morning from opposing counsel about, oh, what about this emergency situation where the legislature does choose to adopt, and maybe there's some problem. Well, that's an emergency of their own creation. If they don't adopt the law, there will be no problem in that way. They should let the law go to the people, which is the intention of this constitutional provision. And then if it's adopted, there'll be plenty of time in the next legislative session before the proposal would take effect, if it's adopted, to make those amendments. And the language of 2.9 permits that in the next legislative session, it can be amended. So I think that's the approach here, the fundamental difference.
For referendum.
Referendum, Your Honor, but again, we have, all these are grants in terms of what can be done by the legislature. If an initiative is adopted, they put some rules on the legislature in terms of it takes a 3/4 majority to amend that. But again, these are grants of power to the legislature under the condition the people set out in Article 2, Section 9. So this is not about plenary power by the legislature at all. This is an exception to that. And that exception was accepted for 105 years. The legislature never attempted to do this since this provision was added to the Constitution originally in 1913. It was confirmed in the opinion that Judge Reardon referenced from then Senator Milliken to Attorney General Kelly. No, Your Honor, that's fine. But again, I think on a bipartisan basis, future Governor Milliken wanted to know, Democratic Attorney General responded, adopt amend is not permitted. That confirmed the understanding. And again, we have at length in our brief, if you find needed, we went through the common understanding analysis, and there's not a word, no hint at all that the people would have understood that the legislature can step in, snatch away their right to go to the ballot, and then gut the proposal.
Could we just say that the 64 Attorney General opinion was binding on the legislature?
No, Your Honor, I think as a matter of separation of powers, I don't think it is. I tend to agree with the case law that says that that's binding on the executive branch, certainly not binding on a court. But I think even though in this case, it was interesting that the legislature essentially sought permission from then Attorney General Schuette to do what it did. But again, my view is I don't think that an Attorney General opinion binds the legislature as a matter of separation of powers. It's certainly something they should take into account, as they should take into account the lengthy history here with nobody disputing it. And that history has impact. We cited this in our brief, that a contemporaneous construction, as Attorney General Kelly's was in 1964, is entitled to some weight in the court's analysis. It's not definitive, but is entitled to some weight. And again, this 105-year practice. The other point I'd like to talk about.
Well, can
Yes,
I
Your
ask
Honor.
a question? It's the same one I asked Ms. Sherman is understanding your argument about the restrictions and those restrictions are all within that 40-day time period. When I read this, I look at the plain language and I say, okay, the people said you can't amend a something that was subject to referendum until the next legislative session. In Article 2, Section 9, it says that. Yet it doesn't say that for initiative laws. And so once you get past the 40 days, I go back and say, well, okay, I mean, anyone reading this out of high school would say, okay, well, they said you can't do it for referendum, so I guess you can do it for initiative laws. Why is that wrong?
Well, with all due respect, Your Honor, I don't think a voter of this state, knowing that they have the right of initiative, I think they'd be stunned to find out that the legislature can adopt their proposal 1 month and take it away.
You're not answering my question. My question is, if the people adopted the specific remedy that the trial court said applied to initiatives, but it only applies to referendums in the Constitution, why wouldn't that be the natural reading of the document?
Your Honor, I think the natural reading of the document is that those three options are the only options available to the sitting legislature.
But that's during the 40 days.
That's during that entire legislative session when this is presented
But it doesn't
to
say
the
that. It
legislature.
says those options are in the 40 days so that the
That's-
legislature doesn't sit on its rear end.
If I may, Your Honor, that's when they are to be exercised
Right.
during those 40 days, so that if the legislature either chooses to put an alternative on the ballot or chooses to do nothing, you can get to the ballot. We don't want a situation where the legislature can simply sit on it and essentially
Right.
veto and prevent it from getting to the ballot.
Right.
Here we have the opposite situation where, again, the legislature adopted it only to gut it. I would also like to, address the Farm Bureau case, which I think is very instructive here, if I may. In that case, the Michigan Supreme Court confronted a legislature which, in order to avoid a referendum, was serially adopting daylight savings time and then repealing it. That was the scheme that they came up with there. And this is, again, Your Honor's pointed out the lengthy history of many of us in the elections in this state. The legislature consistently over the last century has tried to find every possible way to gut the initiative laws. In that case, it was this serial amendment and repeal. And the court said, we're not going to allow that because that would allow the evisceration of this right. And so I think as you construe and look at this language, that is a very, very important principle because you here have basically the initiative equivalent of what happened in Farm Bureau. And I think the Michigan Supreme Court was quite clear there that in construing this constitutional provision, the courts are to lean in favor of the voters and of their right to make an initiative. And as Ms. Sherman pointed out, the legislature has ample alternatives. They can put their own proposal on the ballot. They can work to defeat the proposal. They can put a constitutional amendment on the ballot to overrule what people have wanted. But the people for over a century have reserved this right to go to the ballot directly. And they've taken it away from the legislature very clearly and have told the legislature, you cannot interfere. We're going to have some direct democracy in this state. And I'll leave you with this. If what the legislature did here is allowed, what are the limits? I think the right to initiative will essentially disappear in this state because any legislature in cahoots with any governor on any initiative they don't like can simply adopt it and then gut it at their convenience during the same session. There's no limiting authority. So essentially what the state and the legislature asks you to do is read the right of initiative out of the state constitution because any legislature, Democratic or Republican, and this crosses partisan boundaries, what we ask you to do is declare this weapon of adopting amendment unconstitutional for everybody. Nobody can use it going forward. They couldn't have used it in 218 and no future legislature can use it as all. They are to stick to the normal course as was understood for 105 years before 2018. With that, I'd be glad to take any further questions. Thank you, Your Honors.
I just have 3 quick points in rebuttal. I think the court fully understands the issues. The first is about Attorney General opinions. I don't think they need to play any role in this case. I just want to clarify the timing of things because the Frank Kelly opinion came in 1964. The Bill Schuette opinion was issued on December 3rd of 2018, and it superseded the 1964 opinion. And then the Public Acts 367 and 368 and 369, amending Public Acts 337 and 338 occurred in December 13th. And it's been a matter of case law that opinions bind state agencies. Now, the legislature sought that opinion and obtained the opinion before it issued or before it amended these laws, but I don't think the court needs to address Attorney General opinions and their binding nature whatsoever in this opinion. That's point 1. Point 2 is this reference to spirit. I think there's a nice piece of analysis from Judge Banstra in the Reynolds opinion, because there actually had been reliance on the spirit in that case as well. And of course, that happened in the Attorney General opinion from 1964 and in the opinion below. And of course, it's not the spirit, it's the best expression of the people's intent is the words they chose to use in writing. And here, the language was unambiguous. So it doesn't require further construction. And then the last point I'd like to make, and this is the fact, the question that Judge Murray asked, he said, well, it doesn't say that session, it says within the 40 session days. And that's really the critical point. If you look at other constitutions that have similar language, in fact, if you look at the legal scholars amicus, they quote the Washington Constitution, and think of the contrast. Because the initiative measures shall be either enacted or rejected without change or amendment by the legislature before the end of regular session. It has the language session. Our Constitution says within 40 days, within 40 session days. That's the only limitation. This court should reverse.
But what about what Mr. Brewer said? Is that you gave the analogy to the daylight savings time case, and you know, if you have the same parties controlling the legislature and the governor, games could be played, and they could just adopt and then decide that we're gonna, you know, keep one subsection out of the original initiative petition and change all the rest of it, which would subvert what the people were trying to accomplish.
The thing about Farm Bureau is that they had textual language which was ambiguous. And in fact, the analysis is predicated on there being an equally concordant, that's the language of the opinion, equally concordant construction of the law. Here, there is no other reading. It is unambiguous. It provides for this very thing. That's why I kind of talked about needed changes. I don't think that that's a necessary part of the analysis, but it shows that there's a basis for it, that there's a basis to allow the legislature to amend within the same session, because there could be a need for a change, like in the Court of Claims Act, there was a change within 6 weeks after its enactment. But I know that's, well, in any event, but the point though is that once it has that authority, whether it's in good faith or not, that's a part of the analysis in Reynolds is that's a political quagmire. You don't make that determination. The legislature has retained this authority. It makes sense that it has the authority. And if the people are unhappy with its exercise, the remedy as described in the advisory opinion is another initiative or to vote them out. This court should reverse, issue a published decision by February 1st, and that the state would ask that it be given immediate effect just to avoid any ambiguity about the ongoing role that the February 19th decision will have, because of course, any appeal taken of this decision, if it does reverse, would stay its effect by the operation of taking the appeal. So the immediate effect would just provide clarity if the court does reverse. Thank you.
All right, thank you. Interesting case. Be submitted.
It was very well argued.
Yes.
Thank you very much.
By all.
Thank you.
Brings us to item number 4, docket number 359427, Carmichael versus Williams.
Place is clearing out.
Anyone? Oh, all right. There only one party was endorsed in that. They don't appear to be here, so that'll be submitted on the briefs. Brings us to item number 6, docket number 358734, the estate of Evelyn Ragsdale versus Bishop.
Good morning, Your Honors.
Morning.
May it please the court, Mike McCulloch on behalf of the appellants Terrence Bishop and Katie Bishop. Your Honors, the appeal before you today is based on questions of law, but there are some rules of law that need to be applied. One is that a clear and unambiguous will needs to be enforced as written. That's in re Raymond. Also, a clear and unambiguous trust needs to be enforced as written. contracts that are clear and unambiguous need to be enforced as written. And when the courts look at a clear and unambiguous will or trust or contract, the intent of the parties is included in that document. In other words, extrinsic evidence regarding the testator's intent is not allowed if the will is clear and unambiguous. Same with the trust, same with the contract. In this case, Shriners, in its appeal brief, has narrated facts which are not supported by any testimony transcript and can be characterized as extrinsic evidence that should not be considered because there's nothing ambiguous about Evelyn Ragsdale's estate plan. So when you apply the clear and unambiguous language of the will and the trust, it's clear that Evelyn wanted her estate to be funded by the Select Trust, which was managed by Comerica Bank. Evelyn Ragsdale made her bank accounts joint with Katie Bishop prior to her death. Those bank accounts were a non-probate transfer that went to Katie Bishop and were not included in Evelyn's probate estate. Consequently, the probate estate lacked readily marketable assets. And in doing so, it triggered the funding mechanism in Evelyn's Select Trust. I'm not going to belabor the facts, we've laid them out in the briefs, but I do want to point out that Shriner's narrative of the facts should not and cannot be considered under our appellate rules. If you apply the rules of construction, that is, clear and unambiguous documents need to be enforced as written, it is quite clear that Shriners has no claim in this case. Rather, any recovery by the estate or any recovery by an assignee of the estate or any recovery by a subrogee of the estate must be distributed to Terrence Bishop as a residuary devisee under the will. The will clearly states that all other property that Evelyn owns shall be given to Terrence Bishop. Now, the rules, again, a question of law, the rules regarding assignments and the rules regarding subrogation are quite clear. An assignee or a subrogee acquires no greater rights.
Shouldn't we get to the bottom, or shouldn't somebody get to the bottom as to whether or not Katie Bishop misappropriated $590,000?
One would have to.
She's potentially walking away with $600,000 that may have been stolen. And then if it was stolen, it rightfully belonged to the Shriners.
I disagree, Your Honor. And the reason being is that the person having the right of claim would be the estate. And the estate clearly says, the will clearly says that any other property goes to Terrence Bishop. How do you get to, I question.
The Shriners would have no say at all in your interpretation.
Well, Shriners did have a say, but there was a stipulated order back in January of 2020 that provided for estate funding. If Shriners was concerned about the recovery of these bank accounts, it would have said, hey, we reserve the right to reimbursement. We reserve the right to go after Terrence Bishop, and we're not going to agree to fund the estate without that assurance. They did not do that. And in fact, if you look at the transcript from January of 2020, Mr. Cashin tried to say, oh, and if the estate recovers money down the road, it's going to go to Shriners. And I said, no, that's not the agreement. We have a fundamental disagreement here. Look at the order. The order is quite clear. It provides for estate funding, period. And in fact, the Comerica Bank's attorney, Don Schluter at the time said, yeah, the oral presentation here is not what the order states. So if Shriners wanted to retain the right of reimbursement or retain the right of recovery against the bishops, then the estate funding should have been contingent upon reserving those rights, reserving the right to reimbursement. That was not done. So now we are left with the estate having a claim, which the estate proceeded on for a period of months. And as the final act by the trial court, the trial court said, well, we'll send it off to arbitration, but in doing so, hey, Shriners, you get the estate claims, go ahead and pursue them. Okay, if there's an assignment of estate claims, Shriners is in no better position than the estate. Shriners does not have a right to keep the money any more than the estate has the right to keep the money. I don't know how you make the jump from the estate has the right to recover the money, but we're going to give the right to keep that money to Shriners. The estate can't keep the money. The estate has to distribute it according to the will. So now you're changing the terms of the will. Shriners raises Atlanta International versus Bell as the proposition that it's entitled to equitable subrogation. Now, I'm sure the court is aware of the facts in Atlanta International, but I briefly want to summarize them. It involves a claim of professional malpractice against a defense counsel who did not raise the affirmative defense of comparative negligence. Since it was an insurance case, that is, the attorney represented an insured under a liability policy, the insurer could not go directly against the defense attorney. Rather, the insurer had to use the doctrine of equitable subrogation to take the place of the insured who had the relationship with the attorney. And in that case, the Michigan Supreme Court said that the interests of the insurer and the insured were merged because it's possible in that context that the defense counsel can act in the best interest of both the insurer and the insured. In this case, the interests are not merged. The estate owes no duty to Shriners. Shriners owes no duty to the estate. The bishops owe no duty to the estate or Shriners. So there is no special relationship which can be the predicate for equitable subrogation based on Atlanta International. Again, if you apply the clear and unambiguous terms of the will and the select trust, it's clear that any recovery is subject to Evelyn's will, and that goes to Terrence Bishop as residuary devisee. Again, in answer to your question, Judge Reardon, if Shriners was concerned about getting the recovery and applying it to their gift, action should have been taken in January of 2020. It did not take action. It did not reserve those rights. And now Shriners wants to revive those rights and say, well, I should be able to go after the bishops in arbitration. I should be able to keep the recovery. That would fly in the face of rules of construction dealing with clear and unambiguous wills and documents and things of that nature. It would also fly in the face of the rule regarding assignments and subrogation. You can't put Shriners in a better position than the estate. Shriners is not entitled to keep that money. One other item I want to mention, if Comerica Bank is correct, that the funding of the estate creates more of a creditor-debtor relationship. That is, the estate is the creditor and the select trust is the debtor. And therefore, Comerica Bank owes no fiduciary duty to the bishops. I would suggest to you that that analysis is incorrect. The bishops were beneficiaries under the select trust. Their bequests under the will, specific bequests, were funded by Comerica Bank. Now, Comerica Bank says, well, since our liability was fixed, those bequests were for specific amounts, therefore no fiduciary duty was owed to them. Well, then you would deprive any devisee of a specific gift, any beneficiary of a specific gift, of a fiduciary duty expected of the trustee. Both the personal representative and the trustee owe duties of loyalty, impartiality, and acting solely in the best interest of beneficiaries. Comerica, by offering to assign its claims which Comerica Bank itself doesn't even recognize, they violated their duties. They owe duties to the bishops as devisees under Evelyn's will. Same with the estate. The estate violated its duties when it offers to assign its claims to Shriners. One thing I would just point out is that errors of law are always subject to review. Even though this case was referred to arbitration as the final act by the trial court, errors of law are always subject to review. And I cite TSP Services versus National Standard 329 Mishap 615. That case stands for the proposition that if the trial court makes an error of law, or if the arbitrator makes an error of law, it's always subject to review by this court. And so I would ask the court to vacate the trial court's final order that assigned claims over to Shriners, and dismiss this case because any recovery by the estate would belong to Terrence Bishop as a residuary devisee. I'm happy to answer any questions you have.
Thank you. You
Thank
do
you.
have time for rebuttal if you want.
Yes, thank you. I appreciate that. Sure.
Morning, Your Honors. I'm Bill Cashin, appearing on behalf of Shriners Hospitals for Children.
Both arguing here?
Yes, and we'll split our time, and I don't believe we'll use it all, Your Honors. First of all, this isn't a will contest case, so I don't understand why there's arguments based on the will. Second of all, the whole premise of the appeal appears to be that, well, Terrence Bishop gets everything anyway, so just dismiss this all.
He's a residual there, isn't he?
He's a residual beneficiary. The lawsuit is against Katie Bishop, who was the joint account owner to recover that money to the estate. Now, where does that money go once it's recovered to the estate? Well, there's a lot of things that come into play under probate law, and the residual beneficiaries are last. You pay all the claims in the estate, all the creditors, all the attorney fees, all your allowances. So you can't just say, since I was a residual beneficiary, it's intended I get everything, because that's not what a residual beneficiary is under the law. That is not how estates are even probated. That's part of the problem I have coming here is appellant asked for this case to be dismissed to go to arbitration. And it was dismissed without prejudice at appellant's request based upon a boilerplate arbitration clause they found in Comerica's online, customer account agreement that's 50 or whatever pages long. So we have a dismissal without prejudice. Nothing has been decided on the merits in this case, despite it pending for as long as it has. There's been no adjudication whatsoever. This is quite simply a convenience account case. Did Evelyn Ragsdale intend to gift all the money in her joint bank account, which defunded all the gifts under her trust, contrary to what her estate planning attorney said they planned out? Or was she put on the account for convenience? We need to reach that issue. We have not reached that issue. So I do not believe we have any final order that adjudicates the rights of the parties upon which to predicate an appeal. As to standing, counsel's a little disingenuous. When the order was done to pay under the select trust account, we had our petition to intervene pending. Those proceedings were going on. We were allowed to intervene specifically because Comerica paid $900,000 to the estate. So we believe, and why did the estate need that money? We say because the state was subject to a fraudulent act of Katie Bishop taking these accounts when she was only on the account for convenience. And if that money was part of her estate, all the bequests under her will would have been funded. So they are not, the estate and the Bishops are not beneficiaries under the Comerica account. The only beneficiary is Shriners. The creator of that, the testator, if you will, was Evelyn Ragsdale and her husband. So it's a revocable trust. They can take the money out of that trust anytime they want and claw it back. That's the effect of the clause saying, if my estate is insolvent, then I withdraw money from my trust. That does not make the estate or the beneficiaries in the estate beneficiaries of the Comerica trust account. So we certainly believe we had standing. Standing and the real party and interest rule are two different things, and they put them together. Standing is, do you have a stake in the outcome of the proceeding? Obviously, Shriners have standing because they're out the $900,000 they would have otherwise received. The real party and interest rule would, of course, say that the trustee has to pursue that cause of action. But as the court stated in that plenary and quoted from the restatement of trust second, that where the trustee does not act, the beneficiaries have an equitable right to act. So we think at the time the probate court made the decisions it did, there were proper decisions. We did have standing and we did have real party and interest status because Comerica was not acting. We then went through all the discovery for a year or so. Then when it's scheduled for jury trial, that's when appellants file their motion saying Comerica is a necessary party and look at this arbitration agreement. So that was granted. I believe we had standing then. any question of standing or real party and interest is now, of course, moot because both the estate and Comerica have assigned their causes of action to Shriners. So I think that renders all that moot, and you can't say, well, I think you did have standing 3 years ago. We're talking about a 2019 order is really what he's trying to appeal here. But you can't say you didn't have standing then, so dismiss it even though you have legal standing now. That would have been a dismissal without prejudice then for lack of standing. I should still get the assignment and still pursue this. And it does not change anyone's obligations under contract. The bishops have no contractual obligations that are affected here. They're the residual beneficiaries and they get whatever's left in the estate. If we have this recovery, Shriners has a claim against the estate. If the court denies that claim, then Terrence Bishop will get these funds back. If for some reason through the probate of the estate, they do not get repaid to Shriners, but that's not a defense to say, well, let's just say I get it back anyway. So let's never look at whether Terry Bishop wrongfully or his wife wrongfully took these funds or not. So we don't believe there's a final order. We believe we did have standing and we could act now that we have the assignment. We don't think there's any question there. So we would ask that the appeal be denied and the matter be allowed to proceed to arbitration. Thank you.
May it please the court, Lawrence Dudak, Northampton, on behalf of Comerica Bank trustee. We would agree entirely with Mr. McCullough that the clear and unambiguous provisions of the trust agreement should be enforced by this court. And reviewing those clear and unambiguous provisions, it is quite clear that Comerica acted faithfully to fulfill its obligations as trustee. First, the trust agreement required Comerica to fund the estate to the extent that money was required in order to fund the expenses of administration, pay creditor claims, and pay bequests. Comerica did that. It paid $900,000 from the select trust to the estate to fund payment of all those expenses. The select trust agreement further provided that Comerica Bank was to take the remaining funds and pay it to the sole beneficiary under the trust, Shriners. Comerica did that, paid approximately $1.1 million to Shriners in fulfillment of that obligation. Comerica has fully and faithfully executed each and every obligation that it had under this trust agreement. I don't understand what this alleged breach of fiduciary duty is. First of all, there is no fiduciary duty owed to a devotee under the will. Any duty that Comerica has is limited to a duty owed to the personal representative of the estate. Second, there's been no factual basis alleged to support a breach of fiduciary duty. The bishops would impose on Comerica some obligation to engage in some extensive due diligence to investigate whether this claim has merit, whether it should be pursued, to engage in discovery, to take other actions, to research it, to incur a lot of time, cost, and expense in doing so. Nothing under the trust agreement imposes any such obligation on Comerica. To the contrary, the trust agreement itself provides, number one, that Comerica may within its discretion settle claims, that it may abandon claims, and that it may dispose of trust assets. So in this case, as a practical solution to the issues presented, Comerica agreed with Shriners, we will assign the claims to you if they exist. Shriners, you may then pursue the claims against the bishops, and we exchange simply want to be indemnified. Each and every one of those actions was permitted to Comerica under the trust agreement, and Comerica acted entirely appropriately and properly to fulfill its fiduciary duties under the trust. We would ask that the ruling of the circuit court be affirmed. Thank you.
Shriners made a comment during his presentation that it made a claim against the estate. That is not true. And to make a claim against the estate as a creditor, they would have to allege that the decedent, Evelyn Ragsdale, is indebted to Shriners, that Evelyn Ragsdale owes Shriners some money. Well, under these circumstances, that's like biting the hand that feeds you. Evelyn Ragsdale set up the trust. Evelyn Ragsdale wrote the will. And so therefore, if Shriners says, well, Evelyn Ragsdale owes us money and we're making a claim against her estate, what's the basis for that? Evelyn Ragsdale is not obligated to Shriners. In fact, Shriners should be thanking Evelyn for the $1 million that it received. Second, as far as the assignment is concerned, that was the last act of the trial court as we were going out the door. That wasn't something that happened early on and we had a chance to litigate it. Rather, the trial court said, well, we're going to send it off to arbitration. And oh, by the way, we'll assign these claims and good luck to you, Shriners. Well, where does that leave the bishops in terms of being a residuary devisee? If Shriners has not made a claim against the estate, why is Terry Bishop being denied the residual under her probate estate? There is nothing that comes in front of Terry Bishop in terms of receiving whatever the estate recovers. All the bequests have been paid. All the administrative expenses have been paid. Mr. Taylor, the personal representative's attorney, stated in his brief that I've done everything. Everybody's been paid in full. There's nothing left to do. And any recovery by the estate is going to go to Terrence Bishop anyway. It's an exercise in futility. That's exactly what the personal representative said. I didn't say that. The personal representative did during the September 13th, 2021 hearing. So there's no different result that should happen because Shriners wants to pursue claims in arbitration. It's an exercise in futility. As far as Comerica Bank's argument that, hey, we don't owe a duty to the bishops, again, take a look at the terms of the select trust. They have an obligation to pay bequests, pay bequests. They paid the estate so that the estate was funded. The bishops were devisees under Evelyn's will. They received money from Comerica Bank. They had a beneficial interest in that select trust. They're owed fiduciary duties. And the assignment of the estate claims and the select trust claims to Shriners destroys the duties that are otherwise owed to the bishops. The bishops are owed fiduciary duties in the estate and in the select trust. When you assign claims and give it to a third party like Shriners that has no duty to the bishops at all, you've destroyed those fiduciary duties. You've deprived them of the protections, loyalty, impartiality, and so forth by giving it to a party, Shriners, who's motivated simply to recover money. That's not what Evelyn intended. If you look at the four corners of the documents, you can't go beyond that to try and discern her intent. And I would ask the court to vacate the assignment and instruct the trial court to dismiss this case and adopt the settlement agreement that was agreed early on between the personal representative and the bishops. Thank you.
Thank you all
Thank you.
very much.
Have a good day.
That concludes our 10 o'clock call. We'll take a brief recess before we start the 11.
All right.
Okay, we'll continue on with item number 7, docket number 359092, Alexander Queen versus Woodbury Green Condominium Association.
Morning, Your Honors. May it please the court, Brian Gerda on behalf of the defendant appellant Woodbury Green Condominium Association. This is our appeal of the circuit court granting the plaintiff, Mr. Queen's motion for summary disposition that was brought MCR 2.116 C10 prior to a scheduling order being issued in the case, prior to any discovery being done in the case. The complaint in this matter was brought against my client, the condominium association, for a prescriptive easement. Prescriptive easement is akin to adverse possession. The plaintiff wants legal and free use of my client's property, a portion thereof, a portion that's described as an 11-foot gravel driveway throughout the pleadings. A prescriptive easement has 7 clear defined requirements that must be proven in court for a plaintiff to be able to obtain a prescriptive easement. Those are actual, continuous, open, notorious, exclusive, hostile, and uninterrupted use. Those are all required. There's no or, it's an and. You need all 7. In the lower court, time in use was most focused on by the court as well as the plaintiff. It is pled that the driveway was used for its current purpose, a gravel driveway, since 1965.
There's actually a curb cut in, wasn't there?
There was, yes, Your Honor. And that curb cut was cut in by my client. And that's very, very important. And that was
Yeah, I think
stated in
it
the
is too.
complaint.
Why would they cut a curb in if they're not going to use it?
Well, why would they cut a curb cut if they weren't allowing?
Well, allowing, that's what I mean.
Yeah.
If they weren't allowing to use it, yeah.
Right. And so the pleading itself doesn't meet the requirements for a prescriptive easement because of that acknowledgement alone. I think that just screams evidence that my client was like, yes, you may use this area of ours to traverse, to travel across. Now, permission to use land defeats a prescriptive easement. That defeats the hostile element of the 7. And we've cited that case law in our brief. We cited that very same case law to lower court. A use is not hostile or notorious if it is permissive. That's the good all case. The King case also stated that peaceable occupation or use by acquiescence or permission of the owner cannot ripen into title by adverse possession, no matter how long maintained. Lower court here really focused on the fact that the plaintiff had been using this driveway for so long. And I can understand that. That's certainly a consideration that would float around your mind. But we still need to have each and every element. And so it's our position that all along, my client has allowed the plaintiff to use this particular area. Now, my client is a condominium association. It is run by a board of people who are elected. This board changes consistently. So it's not that I can go to my client and get all the factual information I would need, all the affidavits I would need to defeat a C10 motion, to make a clear picture to lower court of what kind of permission existed. I can't even say that at this point. I would need the discovery process to do so. There are prior board members that we need to subpoena and or depose or get documents as to what even allowed this initial use to begin. We don't know. It wasn't pled. There was no evidence submitted before the trial court. Thus, the trial court could not have made a decision on the merits of whether or not permission existed for there to be a prescriptive easement. In fact, I think what really led to the court ultimately making its decision after already having the feeling of how much time has passed is when I stated what my client might want to do with its property. So this easement, if you will, that they're trying to obtain, this driveway use, goes into a main entryway into our association. My client has an idea that they may want to put up some nice shrubbery along the sides of the road as a nice entranceway. Lower court judge didn't like that when I said that. That would be to deny somebody who's been using permissibly in our possession a gravel driveway, no longer the right to do so. But that's not an element of prescriptive easement. My client has property rights. In order to take them away, which is what the plaintiff is seeking, a declaration that would take away my client's rights to his property, all 7 elements of prescriptive easement must be met. So that's really the crux of our position. The easement, the use was permissive, therefore there can be no prescriptive easement assigned. And furthermore, this was a premature decision by the lower court. Now, some cases are appropriate. They can be decided on a C-10 before discovery is ever issued. This is not that type of case. There's a real question about what the full makeup of that permissive use was. I can't define it just yet at all. So we need discovery to be open in order to figure that out. And only then should the lower court be able to consider a C-10 motion. Any of your questions, thank you for your time this morning.
Thank you.
Please, the court. My name is John Day, and I represent Alexander Queen in this matter. Mr. Queen bought this property in December of 2020. He bought it from the Katona family who had owned the property for in excess of 30 years. The driveway in question, the route of the driveway, the connection to the access driveway of the condominium association was in existence on the day that the Katonas purchased the property and had been for some time prior to that date. It was an open, continuous use. In support of our motion for summary disposition in this case, we supplied pictures, we supplied surveys, we supplied affidavits, we supplied governmental permits that have been issued on the property, all showing the establishment and the location of this use for over 30 years. The issues on
That's fine, but was it adverse? Was the use adverse?
Adverse, yes. If you look at the letter that they sent to my clients on October the 1st of 2020, it clearly says that number one, the use is unapproved, not permitted, unapproved, and that it represents a liability to the association. That was also in the evidentiary record. The only thing that the appellant offered the court at all was what's referred to as a curb cut. Technically, I guess if we went into it, it's not really a curb cut, the curb ends. So it wasn't cut in, it just ends prior to where the driveway is. The trial court specifically asked the appellant at that time when the curb was established. He couldn't answer. He couldn't answer when the driveway was established. He couldn't answer any of that. The letter of October the 1st went on, which was unrefuted by the appellant and which was from their secretary, clearly stated that this particular use was not permitted, that there was no agreement and there was no easement granted by the association for this use. The court, and what I find interesting with the appellant's argument is while we agree with the law, one of the cases which we relied on heavily, which I think the court also relied on, was the Marilette car wash case cited by the Michigan Supreme Court. That court clearly said that where you have a long time use of property, the burden of going forward on the issue of permissive use shifts to the subservient estate. It wasn't our obligation at that point to show that it was permissive, or sorry, that it was not permissive. It was their obligation to show that it wasn't permissive. We then go to the record that was established.
Well, looking at that letter, they do include language in that letter saying the access will no longer be available.
Yes.
Doesn't that strike a permissiveness?
No.
I think it might be a factual issue.
No, after 30 years, and the establishment of the easement, you cannot just terminate it. It was already established, and if you reading the cases that are recited in the brief, it talks about the fact that once established, is there and it doesn't go away. And then the new owner has the right to come into court and petition the court to actually recognize it and establish it. Once it gets past
So you're
15
saying
years, it's
adverse
vested.
Adverse possession was already established.
Exactly. 15 years or, after
But
15
where-
years,
but
it's
where-
established.
What evidence are you relying on to say that it was adverse prior to, I mean, the only thing I heard you, and maybe I missed it, is the letter that the condo association sent in 2020 or 21, whatever it was. What was it before? Because I mean, this, curb cut, whatever we're calling it, does somewhat suggest that they allowed the use of that driveway there. Otherwise, they would have kept going with the curb.
Michigan Supreme Court in the Marlette case stated, it is evident under both Workman and Hobb, when a claimant can demonstrate that a predecessor in interest met the requirements for the establishment of a prescriptive easement, the vested easement transfers to subsequent property owners in the chain of title without obligation to show privity of estate. Workman and Hobb also hold that when the property has been adversely used in excess of the prescriptive period for a substantial period of time, the burden shifts to the subservient estate owner to show that the use was merely permissive. We affirm these principles in this case.
Okay, I don't disagree with any of that, but my question is, what shows that it was adverse in the 15 years before your client bought the property?
The question, what the court is stating here is the burden of going forward is shifted. And it's up to the subservient estate now to introduce proof to show that it was permissive.
Oh, isn't the curb cut proof? When was the curb
No,
cut? Hang on. When was the curb cut made, or when was that?
Well, that's what's interesting about this, because
That's a factual issue to me.
okay, and the court specifically asked the appellant, when was the curb cut made? Keeping in mind, he's admitted today as well, they're the one that put it in, but they can't say when they did it. If it was put in 3 weeks ago, that's not sufficient. It doesn't say why it was put in. Is it?
Discovery was conducted in the case. No.
All right.
Right?
No, there was no discovery submitted. However, he didn't file an affidavit as provided for by the court rule stating that further discovery would show this. And that's where the problem is. Had he submitted an evidence, because the problem I have is, if you read the cases on that, they talk about the discovery that he needs because he can't get it himself. He has to get it from me. All of the evidence on that curb cut is on his side. He did nothing. And it's not like this motion popped up out of nowhere. This motion wasn't filed till 8 months after the case was filed. And all he had to do was to file an affidavit stating that he needed additional time because he believed he could get evidence to show that this curb cut somehow established permissive use. He didn't do that. And the curb cut is an inanimate object. It just sits there. It could be there because the engineer designed it that way. It could be there because of cost cutting. It could be there because they ran out of material to keep the curb cut going. It doesn't state permissive one way or another. It's just there. And it's
The way
silent.
that the gravel road, take a look at the picture again. Gravel road seems to go right where the curb,
The
what
gravel,
we're calling the curb cut.
the gravel road goes to where the curb cut stops. Now, is that because it was permitted and the curb cut was put in after the road, or was the road put in after the curb cut was established? They just went around the curb. But there's no evidence, and we're not the one, according to the Supreme Court, that was obligated at this stage of the case to provide evidence on the issue of permissiveness. That was on him. And all he had to do was say, court, I need more time because I can get affidavits from these people, and I haven't been able to do that. Or that we think that this curb cut can somehow establish that because we believe it was put in after or when the road was put in. For all we know, that curb cut was put in when the association was built, and my client just basically put his driveway at the end of the curb cut where it stopped. There's no proof one way or another, and the burden is not on me. It's on, after 30 years, it's on him to produce the proof. He didn't do it. This is a situation where the appellant did not meet his burden of proof below
leaving the court under the court rule to say that you haven't met your burden of proof, summary disposition is appropriate.
Anything else?
I'm just trying to think of another reason why they would even have that curb cut there other than allow permissive use.
Your Honor, as I said, the curb ends 400 or 500 feet from the road. It's possible they no longer felt they needed a curb because the road has no curb at Haggerty Road. There's any number of facts, but our problem isn't, we're trying to guess that, but it was his obligation in the court below to at least put up an affidavit to provide the court with some information. He did not do that. All he said was there is a curb that stops there, and I want to speculate without an affidavit, without a request for discovery, without anything further. And at that point, the court was within its rights and actually required, because he hadn't submitted the evidentiary requirement under the court rule, you know, it was a 216G.
Well, you're supposed to look at it. You're right, obviously, about all that, but it's also true with all summary disposition motions that you have to look at it in the light most favorable to the non-moving party. And you don't think there's a reasonable inference that the existence of that curb cut, which was there in front of the court because it was a photograph, is a reasonable inference is that it was put there by the condo association to accommodate the prior owners?
Your Honor, if we had an affidavit.
No, why can't a judge just look at the picture, see that it exists, and say, you know, as Judge Reardon has said, one of the possible reasons why that is there is because the condo association decided we'll allow them to continue to use the driveway off of our driveway.
But that's not exact. That is not what the letter of the 20th, of the 1st of October, 2020 said. It said there is no agreement, there is no easement, and the use is unpermitted.
I don't think there's no easement or other agreement on record for access and maintenance. All right. Could it have been an oral agreement?
Mr. Sir, I thought I turned this thing off.
Better you than me.
I apologize.
I saw you trying to turn it off.
That's what I tried.
Sometimes they're tricky.
Anyway, I think we understand what the arguments are.
I mean, our position is that basically there's no question there's a curb, but we have 30 years and the Supreme Court shifts the burden to show permissiveness onto them. And they didn't submit an affidavit saying, please disregard our letter. We didn't mean what we said. They just said that there's an inanimate object out there. And based on that inanimate object, we want you to speculate without further things else, without us even telling we can add more. And we want you to deny the motion. The court properly applied the court rule, properly applied the decision of the Supreme Court, and the rule should, in this case, should be affirmed.
Thank you.
Okay, thank
Thank you.
I thank you.
Donald?
Your Honors, the lower court didn't make a factual determination as to whether or not this was permissive use or not. Court did not go through the elements in reaching its decision. As part of our position here in appeals, that they really only factored in time. That's the only thing that led to the lower court's decision being made. A burden shift to the defendant to prove that something was permissive does not conflict with our position whatsoever. If it is our burden to find out more permissive use, we will certainly go about and doing that. We need
anything, any affidavit in response to the motion?
No, just the reliance on their own admission that the curb cut was put in by my client. And again, we need to go back, way back in time to people that we can't even identify just yet to find out more facts about that permissive use when it came about. So the burden shift does not contradict with our position whatsoever. We just need the discovery period. And again, that motion being granted for the wrong reasons was also granted prematurely. So thank you.
All right, thank you. Case will be submitted. Brings us to item number 8, docket number 359-299, People versus Ricardo Warren Edmonds. Good afternoon. May it please the court, Jonathan Simon on behalf of Mr. Edmonds. Mr. Edmonds was convicted of home invasion and aggravated stalking. He appealed and this was pre-Lockridge, and the decisions were affirmed. Subsequent to Lockridge, he filed a motion for relief from judgment, which was denied after exhausting his state appellate rights. He filed a petition for writ of habeas corpus. The United States District Court ordered a remand for resentencing, and the Sixth Circuit Court affirmed. On resentencing, he did receive the benefit of a somewhat reduced sentence. However, I have challenged the assessment of OV10, which is predatory conduct. Mr. Edmonds, in his supplemental brief, has raised the issue of the propriety of the assessment of points for OV4, mental anguish. He's also raised an issue which is not related to sentencing. If either OV4 or OV10 were changed, it would change the guideline range somewhat. And if both were changed and reduced, it would change the guideline range significantly. We're asking the court to reduce. What's your issue with 10? 10, well, there's two issues. And that would be one, that it was not pre-offense conduct. And two, it was not conduct related to the sentencing offense. The sentencing offense was home invasion. The so-called predatory conduct involved a different offense, which was the aggravated stalking. So we submit that on both of those grounds, the points for OV10 were improvidently scored. And at a minimum, there should be a reduction for that variable. And if the court agrees with Mr. Edmonds' supplemental brief, there should be a further reduction. Okay, thank you.
Morning again for the record, Assistant Prosecutor Danielle Walton from the Oakland County Prosecutor's Office, representing the plaintiff appellee, the people of the state of Michigan. Just briefly on offense variable 10, but before that, I know sometimes the court likes to know when members of the victim's family are present, the victim and members of our family are present today. So this case presents the prototypical example of when conduct should be scored for predatory conduct. First of all, it's absolutely clear the victim was vulnerable due to her domestic relationship with the defendant and victimized specifically because of this relationship. And I think the court could find that defendant was laying in wait outside her home prior to the home invasion. And we know the purpose of why he was laying in wait, because he stated to the neighbor he was going to crack her head through the wall. And the court relied on laying in wait for scoring predatory conduct. But I think the key example, the prime example, is the fact that defendant stalked the victim in the months or the weeks preceding the home invasion. And both our Supreme Court in Houston and Cannon stated that this type of conduct is what the legislature was thinking of when we're scoring for offense variable 10. And I think for offense variable 4, the court was absolutely clear that it could score. The victim went to counseling in Haven and was still in counseling 9 years later. So unless the court has further questions regarding this case, I would rely on the brief.
Thank you. No questions.
It's been
Thank
a
you,
long
Your
morning
Honors.
for you.
Okay, thank you, Mr. Simon. Case will be submitted. Brings us to item 10, docket number 358192, Joseph Hirsch versus Alicia Garofalo.
Good afternoon, Your Honors. My name is Ron Ancho, Cummings, McClory, Davison Ancho, representing Joe and Kelly Hershey. Your Honor, misrepresentations are not tolerated by the courts, but there are several misrepresentations that occurred here. This is a simple case, but the facts got convoluted because we wound up having 3 different judges, okay? And so as a consequence, it was never made clear, because how can you buy a $500,000 house when you only have $300 in the bank? There has to be a way of doing it. The defendant represented that she had a lot of money in her retirement account, which she did, $506,000. The credit union pre-approved her, not for the 448. And this is before the purchase agreement was signed. So the Hershey's asked, does she have sufficient funds? Oh yeah, we've checked her out. She has more than enough money to close on the house. Based upon those representations, they agreed to sell the house. They had the only house on the market and they got a good price.
Doesn't matter what they said, when you have a provision in the purchase agreement that says all of their prior agreements don't count for anything.
Well, first of all, fraud is an exception in the parole evidence, but here's something that the judges never got right. Now, first of all, let me back up for a second. I'll be right back, the judge. Okay. Nice to see you again, Judge Murray. It's been years. This is a simple case. All we're asking for is a remand for a one-day trial. That's all we're asking for, because there are multiple material issues of fact. Okay. If you're going to take the letter of the contract, it said that she would get approval for 448. Okay. She did. We have a letter. We have an exhibit you got. She was approved for 448. It was set to close. Why didn't it close, judges?
Didn't that letter also say there was a pre-approval?
That was pre-approved, right?
And it's subject to underwriting approval?
Yeah, and she got it. No,
The letter saying it's a pre-approval, but it's still subject to underwriting.
yeah, but judge, she got the approval later after underwriting. No, she was approved for 448. I'm not sure I made that clear. There is an approval letter, not a pre-approval. That's before the.
What's the date of the actual approval letter?
I have it submitted here. Let me try to find it. Let's see.
You have 3 volumes of exhibits. Do you know where it's at as an exhibit?
I'm sorry, Judge, my
You
hearing.
have 3 volumes of exhibits.
Okay.
Can you direct me where it's at in your exhibits?
Yes, it was, again, bear with me, please. I will find it. Where the heck, I had it. We did submit it. I've got it.
Yeah, good, sure. Why?
Credit union exhibit.
What's the date of that letter? Yeah, that's the one that says subject to other conditions.
Well, Judge.
Yeah, that's what I was quoting.
Yeah.
Yeah.
Okay, no.
All right, so that's why I was looking for the letter where you actually, hang on. I was looking for the letter that's actually approves the loan, and there's no such letter there.
There is no denial letter either. There's no denial letter. Now, conditions, judges, are always in every approval. Every approval has 8, 9, 10, 12 conditions. Like you have to have a driver's license, you have to have this, you have to have that. The one condition that she refused to accept was to use the retirement funds.
He was gonna have to pay, what, a $70,000 penalty to pull that out?
But so what?
But where does it say in this integration clause that that's part of it?
It doesn't
That's how
have.
these work.
It doesn't have to. What I'm hearing then is a person, now the credit union had already said she's approved, they set a closing date. Now, the fact of the matter is my clients relied on their representations and Garofalo's. So what you're telling me is you can kill a deal, but according to the Michigan Supreme Court, you cannot create an obstacle to the fulfillment of a condition preceding. Okay, that's in Hayes versus Bayer. She created the obstacle. She made it so that she wouldn't get approved. She even asked them to write a letter denying her approval, and they did.
Doesn't the contract require her to supply a denial letter to your clients?
I mean, that's done all the time.
Yeah.
We never got a denial letter. It's not in the record.
Do you do a lot of real estate work? Because a lot of these arguments are things that are just routine in these transactions. I mean, it's
That's
just not
right, which is why these are material issues of fact that should go to that one-day trial. These are material issues of fact. Was she approved or was she denied?
I don't see anything in the record that says she was approved. And then there's a denial letter, correct?
There's no denial letter of the 448. No, there isn't. There isn't. They denied her for 420. Now, also, let's go back to the purchase agreement. It said she would apply for a 448 loan, right? There's no written 448 application.
There's one that's not signed.
Well, if it's not signed, is it valid?
They processed it. That's what the July 30th letter is.
Well, but that's my point. You can't have it
So
both ways.
These are not material facts.
Yes, they are.
Okay, well.
Okay, did she apply for a 48 loan?
Yes, she
No,
did.
no, she didn't. She wouldn't agree to it. She didn't sign it. But this is my point. These are material issues of fact that a jury ought to decide, not a judge. You know what she testified to? I was going to sell my home. There's nothing that said her home was part of the deal. This is rotten what she did. And the credit union, who's a fiduciary to us, they are, because we have a relationship with them. They abetted her when she said, send me a denial letter for the 420, 9 days after the fact. And they did. They had approved her, subject to her using the money that she said she would. Judge, I sent you, or in the exhibit, she sent a text message, I'm going to use my retirement funds. That was her agreement. The fact that she found out later that was going to be more money than she thought, then she wanted to change the deal. Said, no, I want to get a bridge loan and I want to sell my home, which she did. But why should the Hershey's be punished? Why should they lose 35 grand because she changes her mind? You know what? Buyer's remorse happens all the time.
Security deposit?
10 grand.
Did your clients get that?
No. And guess what? Okay. The Hershey's are good, decent people. He sends an email, said, look, we really wanted to close. We lost money. We'll take the 10 and we'll walk away. You know what her response was? In writing, F you. So guess what? The Hershey's are only looking for a one-day trial to go over these material issues of fact, okay? That's all they want. They lost $35,000 because of the misrepresentations. This is a simple case. The trial court usurped the role of a jury and said, no, you know what? The deal didn't go through. It didn't go through because she killed it because she wouldn't use the money.
But where in the purchase agreement does it say that she needs to use her retirement money?
It's in the communications, the representation.
Prior to the signing of the purchase agreement.
It's not in writing. That's why when there's a
That's why you
fraud,
lose.
You cannot win.
Yeah.
It's impossible
That's
to
the
win.
law. I mean, I don't make the law. And you can throw your papers around all you want, but
Well,
that's
Judge,
the law.
Judge,
okay?
I didn't throw any
You're
papers.
slamming them around up there. You're
No,
upset
I
that our-
didn't.
our
I
women-
fold-
You were showing
I
signs of
folded.
disgust.
Yeah.
I'm sorry.
You were showing signs of disgust with what Judge Kelly said.
Okay,
Yeah.
Judge Kelly.
And that's okay.
No,
I mean,
it's
I'm
not okay.
Okay.
I've been practicing for 47
Okay.
years. I've always shown respect for judges.
I'm not saying that was disrespectful to me.
Well,
I said
yeah.
you're upset
Well,
and you've been a gentleman here. I'm not, there's nothing you've said to us that's offends me. And you've got some clients here and you're trying to do your best.
No, my
All I'm
clients,
saying,
no, my client's not here. That's my
Oh,
family.
oh, it's your family.
That's
Okay.
my wife,
Okay,
Rita,
well, I
and my
beg your pardon.
daughter and my granddaughter. No,
Okay.
first of all, no, but I wouldn't want to show any disrespect. Yes, I disagree because I think it's unfair for a fraud to take place, to say, well, it's integrated. Either the defendant was denied the 448 loan or she wasn't. There's no denial letter that they can produce. And if that's the case, she should have closed. And she wound up really getting a windfall as a result. My client's judge, Murray, I'm sorry, never got the 10 grand. Had they got the 10 grand, we wouldn't have been here.
This is a 10 grand part of the lawsuit? Is it? Okay.
Yeah, we never got it. And the first judge didn't let her have it either, but we never got it. So well, we're asking, look, just remand it for a one-day trial. It's not a big deal. And
It's not the question whether it's a big deal. The question is, does the law require it?
is it fair? Is it the right thing to do? The answer is
It's also probably not the question, but the law is what it is. And our job is to objectively apply the law to the facts, not to decide what we personally believe is fair or not fair.
well, I think we've provided the exceptions to Hamadi, and fraud is one of them. And we would respectfully request, I mean, I understand, how you feel.
Well, I'm sure you could bedazzle a jury with it if it got there. The question is, does it get there? You're very good. And I know your reputation. You're
Judge,
very, very good. lawyer.
Judge, I'm a simple trial lawyer. I really am.
And it shows, it shows.
Judge Murray has kicked my butt more.
No,
than
we
once.
lost it. Well, we settled it, but
I know, but I
it was
didn't
a
wanna-
good settlement for
I
you
didn't
guys.
wanna no, but all kidding aside, this is only a $35,000 case. Ordinarily, I wouldn't even take a case like this. But my clients rightfully feel that they were wrong.
Well, $35,000 is nothing to sneeze at.
No, it
No.
it really isn't. And I believe that if the credit union had not aided and abetted Garofalo by issuing her the denial on the 420, then we'd have got the 10,000 and that'd have been the end of it. But it isn't. And they owed a duty. They really did. My clients were their customers. They owed them a duty to be honest with them. And they shouldn't have issued that 420 denial. I do apologize again, Judge Calvin.
No
Please.
apology
No,
necessary. Please, I probably shouldn't have said what I.
No,
I said.
civility is going out the window. And I'm going to be 77 on Sunday. And I can't tolerate attorneys who are disrespectful or abrasive.
I didn't take it that way. I said you were showing frustration with maybe the law, but certainly not with us. And
Thank you.
please go home and don't think that I thought you were disrespectful to us. I did not. Okay, good.
Good afternoon, Your Honors. Andrew Harold appearing on behalf of the appellee, Alicia Garofalo, who was the proposed buyer of the property. To start, and I think I'll try to keep it brief because I think it's been quite an ordeal just to get to this point. And I, from the context that I'm taking, I think the court is well aware of the law and what's going on here. I would like to point out, on the breach of contract, the PA mandates that if the condition to be approved for financing was not, done and she wasn't approved for the financing after making application, which the record clearly reflects occurred here, that the $10,000 earnest money deposit shall be returned to the buyer. It's a boilerplate language. It's real estate 101. So we had to actually counterclaim for the breach of contract for those monies to be returned. Judge Jarbu was the first of Oakland County, who's now a federal judge, dismissed their breach of contract claim and granted ours for the return of the 10K. All right, so that's sitting in escrow at a title company. That basically that's all that's left here. As to his misrepresentation claims, I'm not going to get here and rehash the record. That's not what we're here for. But I will say this, and I think the record clearly shows, because I did depose Mr. Hirsch and I asked him frankly, did you have any issues with the language in the agreement? He said no. So that there's no other fraud that could be going on there. And I asked him flat out, then what is your problem here? And he flat out said that I was under the impression she was going to be using retirement monies That's the whole point of this. If that is indeed the case, and I'm not saying that is the case, because I don't think my client represented that she's using anything. She didn't have to. If that's the case, and I think Your Honor touched on it, why wasn't that proof of funds made part of the purchase agreement prior to signing the agreement? If he's stating this as that being a condition for why he signed that, then why wasn't that made part and parcel to the agreement? Otherwise, we can sit here and say, you know, I've got a big red dog, you're not allowed on the property. We can say anything that we want. It doesn't matter because it's an integrated agreement, and these representations are not valid. So with that, I'll leave it alone, and I believe that my brief's been submitted and covers all this, and the court should affirm the lower court's rulings. Thank you.
Good afternoon, Your Honors. Mary Rourke Benedetto, appearing on behalf of the defendant Lake Michigan Credit Union. Like my brother counsel, I believe that you have a good grasp on what's going on here based on the briefs. I would like to say I would take exception on behalf of the credit union for the terms aided and abetted. It's criminal. There's no allegations of criminal activity against my client, certainly, nor proof of that. Also, plaintiff has continually referred to some sort of a settlement agreement that the credit union worked out with Ms. Garofalo. It's not true. We represented that in the lower court, represented that in our briefs. That what happened was Ms. Garofalo filed a complaint against the credit union. The credit union filed a motion for summary disposition, and she stipulated to dismiss her complaint against. There's no settlement. There was no money exchange, nothing of that sort. And in this case, what's really interesting is that we have the Hirsches, who are very sophisticated buyers by their own acknowledgement. Joseph Hershey testified. Now, I will also add, in my lifetime, my wife and I have had mortgages. We have a tremendous amount of assets ourselves. We could have paid cash multiple times for our homes. We have never not had conditions that we have to satisfy, general basic conditions. So he's aware of conditions that attach to the purchase of real estate. There was never an approval in this case that was not conditional. Any approval that was given in this case was always conditional. And as counsel has indicated, Ms. Garofalo decided not to meet those conditions. And I also wanted to indicate that counsel said things that said, oh, the Hirsches asked, and the credit union said no. There was never any communication between the credit union and the Hirsches at any direct communication at any point during this litigation. There were no representations made. The fiduciary relationship to which counsel refers is by virtue of the fact that he is a member of the credit union. And the trial judge said just alleging that does not fulfill the obligations of a fiduciary, and especially in the lender borrower segment, there is no fiduciary relationship. The counsel seems to say, well, they never gave her a denial letter for a mortgage for $448,000, but they gave her one for $420,000. It's nonsensical. If she doesn't qualify for 420, she sure as heck is not going to qualify for 448. I think he's trying to rely on the specific provisions of the purchase agreement, some of them, but ignoring the rest of them. There was no approval that was not conditional in this case, so therefore there was never a denial that had to be filed. There was no proof of an intentional interference with a contract. As we've indicated, the trial court previously decided that there was no breach of contract. So plaintiff cannot even fulfill that element of the tortious interference of contract. And again, the trial court reasonably ruled that the defendants here, the credit union, was motivated by a legitimate business reason, which shielded us from the tortious interference claim. With regard to the fraud and misrepresentation claim, the plaintiffs have to show that any reliance on our representations was reasonable. First of all, we didn't knowingly make any false representations here to induce the plaintiff's reliance upon us. And secondly, no reliance could be reasonable where the plaintiff or where Ms. Garofalo never met the conditions of the approval. So unless anyone has any questions.
Not on.
Thank you, Your Honor.
Just 2 minutes.
Sure, okay.
Counsel misstated a couple of things, not on purpose. But she said there were no communication with the Hirsches. That's true. The communication with the realtor of the Hirsches, who communicated to the Hirsches that she had all of this money and getting the loan wouldn't be a problem. Okay, so it was through their agent. The thing that's most troubling is how illogical, where they say, well, you got to follow the written agreement. Well, the written agreement said 448, which she never applied for in right. I mean, which you're supposed to do. Okay. And then she gets the approval for the 448, but then she did get the approval, but she wouldn't meet one of the conditions. And I just want to leave it with this. The Supreme Court says you cannot create an obstacle to fulfillment, okay? And that's what she did. She purposely pulled away what she had put in the application, which was she was going to use the money. Yes, she found out it was going to be a penalty to her more than she realized. But then she should have just walked out of the deal, gave up the security. That's what she should have done. I understand why it happened, but why should my clients suffer because of something she found out later? And so again, I'm not trying to belabor anything. We try to get justice, and justice is not easy to get. And sometimes you try to find a way of doing what's right. And what's right is they should have given up the 10. But if they said, no, we can show that we don't, then going to a one-day trial would make sense. I think fairness would do it. And again, I apologize again. Thank you for your patience. By the way, this case, you have to admit, was simpler than the one you had with the state.
That's for sure.
Judge Murray, it was nice seeing you again. It's been a long time, Judge.
Okay, that case will be submitted. Brings us to item number 11, docket number 360251, Veronica Edgerton versus the Detroit Hotel Services. Oh.
Hello, good afternoon, Your
Good
Honors.
afternoon.
Dora Brantley appearing on behalf of defendant appellant Detroit Hotel Services. This is our appeal of the trial court's order denying defendant's motion for summary disposition based on MCR 2.116C10. The trial court indicated that there was a question of fact whether the hazard was an open and obvious condition, as well as whether or not defendant had notice of the condition. The condition being a metal grate that is inlaid in the carpet in a ballroom at the Detroit Marriott at the Renaissance Center. I think as an initial matter, I would like to just point out some significant facts that I believe are really important to this court's analysis of this dispute. Again, plaintiff claims that she tripped and fell while she was in the ballroom, and she's proceeding to the buffet line where she's planning to get a cup of tea. She claims this is at a 3-day conference, and it's the last day of that conference, and the plaintiff acknowledges that she had been inside that ballroom multiple times over the course of the conference. And when she was in that room, ballroom multiple times over the course of the conference, she noticed these metal grids which cover electrical outlets in the floor.
Notice that they had this defect sticking up, or just notice them?
She noticed the grids. She noticed the grids.
But I mean, the problem is the part that she tripped on, right?
Well,
If
actually,
you see 25 of them and they all look fine, doesn't that sort of hurt your argument?
well, actually not, because what she claims is that the other grids had a tape around them. But she also testified very specifically that she does not know whether or not that molding, which was turned up in the photograph, was turned up before she tripped and fell or was caused by her trip and fall. So if it's caused by her trip and fall, then clearly there's nothing there.
I thought she felt herself catch on something.
She felt herself
Isn't
catch on
that enough
something, but that could be a lip. I mean, just as an analogy, if there's a lip of some carpeting, you can trip and fall over that lip of the carpeting. It doesn't mean that it's necessarily rolled up or defective beforehand. And actually, there's a case that we cite in our brief, although it's unpublished, but I think is very illustrative for our purposes here today, is the Thornsberry versus Detroit Tigers case, which actually addresses some molding, some black molding that was on some stairs. And in that case, the plaintiff actually, his or her foot, I don't care if it was a man or a woman, foot got caught on that molding, and the Court of Appeals indicated that that small lip that's created by the molding, that is still an open and obvious condition. So I think that that's really the problem for the plaintiff in our case, is that one, she doesn't know. And for her to proceed and claim that that is turned up beforehand, that's complete speculation and conjecture. And
Didn't she look back and see it right after she fell?
she did.
So she would have seen it if she had looked down when she was walking in that area.
Absolutely. That is our position exactly. If it was upturned, or even if it was not upturned, had she simply looked down at the floor as she was walking, then she would have seen either the grate in its condition with the molding intact around it, or alternatively, she would have seen the grate with the molding around it that's flipped up. Either way.
Wasn't it though? Weren't there a lot of people in the room, and wasn't it somewhat? I know she said she could see where she was going, so it wasn't, dark, but it was dimly lit in that room.
Very crowded, bunch of tables nearby. If I remember.
Right. What she testified is that she doesn't know. All she could say is that the grate is a few feet from the table. She knows that a gentleman was standing in front of her. And this gentleman, when she fell forward, she tapped that person's back with her fingers. So we know that there's at least some distance. But in addition to that, she's the person who's controlling the distance. She finally admitted that at her deposition, that I am the person that's controlling the distance between myself and the person in front of me, which is quite frankly reasonable. She has no idea whether or not someone's standing on the side of her. There are attendees at this conference. And what she testified is that she's in this conference room, in this ballroom multiple times over the course of the conference. It's always crowded. But despite the fact that it's always crowded, she was able to look down and she sees this grid.
This is when she's on the ground after she fell, right? Imagine people are cleared out, a woman's fallen, right? I mean, we've all been in those situations. There's people checking to see if you're okay, and
perhaps,
circle forms maybe, but the idea doesn't make a big dent in me that she looks over and sees it. Now it's all open and obvious.
Right.
In what was 10 seconds before, a very crowded room, dimly lit with tables nearby.
Well, actually,
sounds like a fact question, actually.
Didn't she also say that the only reason she didn't see the grid immediately before she tripped and fell was because she didn't look at the floor?
Absolutely. That is our position. She was not looking. She very, very clearly testified that she did not look at that floor before as she's traversing through that ballroom, she never looked at the floor. And that is the difference. It will be different, in my opinion, perhaps if she were to say, well, I did casually inspect the floor and I saw nothing. But what she testified is that when she's in that room on multiple occasions before, she is looking at the floor and she sees these grids across the floor. But on this occasion, on this day, for whatever reason, she does not look at the floor.
Is there testimony that she says, I couldn't see it because the room was crowded?
Yeah, there is.
Okay.
That's what she testified.
Okay.
But I think that when you look at it from an objective standpoint, again, there is no one, this room could be crowded, but if there's literally no one, if I'm controlling the space between myself and the person in front of me, I can look at the floor as I'm doing that. She does, at this point, the fact that it's crowded, she doesn't know if anybody's on the sides of her, and what she does know is that this grid is several feet away from the table. The other thing I want to address is, and this court has indicated a couple of times, is about the lighting in the room. And I don't, and perhaps we did not address it as clearly in our brief as I thought that we should have, but I just want to read her testimony as it relates to the lighting. She says, question, when you were in that room before the time you fell, did you have concerns relative to the lighting? Answer, well, it was a room that was kind of, the lighting was dim. It was not bright, I'm sure. Question, well, did you have any difficulty seeing even though the lighting was dim? Answer, no, I didn't have any difficulty seeing, no.
Seeing what?
Seeing anything.
Including a defect, this bag on the floor and dim lights? Was she asked that specifically?
She was.
Or could she see, the guy walking a few feet in front of her?
She was not
Nobody
asked that
said it was pitch
specific.
black, did they?
I did not ask her that specifically, but at the same time, on a motion for summary disposition, can I, or let me finish
Yes, by all
the
means,
reading?
yes,
Okay.
yes, yes.
Question, at the time and on the occasion when you were in the room before you fell, you said that the lighting was dim. Did you have any trouble seeing anything that you looked at? So actually, I apologize. She just said that. Answer, no. So I asked her, anything that you looked at? Answer, no. Question, and at the time you fell, because of the dim lighting, did you have any trouble seeing anything that you looked at? Answer, no. So the lighting does not play an issue in this case. It may be dim, but she clearly acknowledged that the lighting is sufficient for her to see what's there to be seen. And in this case, the grid that's on the floor, that's a black metal grid with the round circle ring in the middle of it, that's got the gray plastic molding, is there to be seen.
Is that what that is? Plastic and not rubber?
Right, I apologize.
That
Rubber.
molding?
It was rubber.
It was rubber?
It was rubber. And if you look at, and I apologize, you're absolutely right, Judge. When you look at the deposition testimony of Mr. Siddiqui, who is the Director of Engineering for the property, he testified that the molding is actually rubber and not plastic. I apologize. So, I think it's also important to point out in this case that in the plaintiff's brief, she advances a narrative that one of the reasons that she was unable to see the grid was because someone was standing on top of the grate or on top of the grid. There's absolutely no evidence to support that. There's also a narrative advance that she was unable to see the grid because of its size or color. Again, there's no evidence of that. She testified solely that she did not look at that floor, and the reason that she didn't see that grid was because of the crowd in the room, despite the fact that she has no knowledge with respect to who's on her side, if anybody, and she's able to control the distance in front of her. The plaintiff argues that this case should be analyzed under an ordinary negligence standard versus a premises liability standard. Yet the plaintiff provides absolutely no legal support for that proposition. Certainly there is a wealth of case law which indicates that courts are not bound by the labels that parties attach to their claims. We cite 2 unpublished cases in our brief. However, that issue was actually—
I don't even understand what would the negligence be?
I agree.
No person that pushed her, or this is a condition of the floor.
Correct. And that is our position completely. The cases that actually acknowledge that it might be ordinary negligence versus premises liability, they turn on active negligence, and there is no active negligence in this case. This court did recently decide that very issue in a published case in Nathan versus David Leader Management. It was released for publication on August 4th, 2022, and it's case number 357420. Again, there's just absolutely no active negligence in this case, which would support this being an ordinary negligence versus a premises liability case. And because it's a premises liability case, we have to analyze the case under the open and obvious doctrine and whether or not that applies. The analysis is objective and not subjective. And in that regard, the plaintiff has to come forth with sufficient evidence to create a genuine issue of material fact that an ordinary user upon casual inspection could not have discovered the existence of the danger. Whether the plaintiffs actually saw the danger is irrelevant to a determination of an open and obvious condition. There is a wealth of case law that has come out of this court with respect to this very issue. We outlined the ones that we found that we thought to be most analogous in our brief. But again, I referred earlier to the Thornsbury case. We believe that that is one of the most analogous cases because it did in fact involve molding as opposed to something else. But there's, the carpet analysis, various issues that this court has decided on with respect to that issue.
Well, how do you square, if it is an objective standard, okay, so we don't look to what her particular, then why do we talk about her looking down and not looking down? I mean, that would only go to comparative negligence. Well, we have to take an ordinary person of average intelligence, would they have seen it under those circumstances? So I mean, does that sort of vitiate your relying on her testimony?
I don't think so. And I don't think so. I think it's just one more point to be made as it relates to why this plaintiff was unable to see
what's one
the condition.
I'm sorry, what is the one more point?
That she was not looking down. It's just one more, is in addition. I agree with you. It's an objective analysis. And what could the average person see had they looked down? But in this case, what we know is that this plaintiff never even looked down to tell us.
But under the objective standards, that shouldn't be a consideration. Maybe that you say, okay, would an objective person have seen her in those circumstances? Yes or no? Then maybe you look to her and say, well, were you watching where you were going? And if not, then that goes to comparative negligence, but not under this analysis to summarily dismissing it under open and obvious.
And I would respectfully disagree with that because I think that there's a wealth of case law which actually counters that. I know that there's,
whether it does or not,
including Lugo.
This is the illogic in this whole doctrine. I mean, we're all over the place with this thing, and we have been since the moment it was first announced to me. It just it's very, and you're citing cases and you're working through it. I understand that.
I certainly understand this court's frustration and opinion with respect to the existing case law, but as this court indicated to one of the prior litigants, this court's duty is to apply the law objectively to the case law or to the facts of the case. And the case law as it currently stands is as it currently stands on open and obvious. And when you even look at the Lugo case, that court talked about how that plaintiff had been traversing through the parking lot. And one of the things that the court was a part of the court's analysis was whether or not this plaintiff had looked down and specifically cited the fact that this plaintiff had not even looked down at the ground. So again, it's not the end all be all. I'm not saying that, the fact that she did not look down, but I am saying that it is just one more building block which supports our position that this is an open and obvious condition. Okay.
It's a clever answer. I give you credit for that. That's good. Yeah.
Okay, so once we get past the open and obvious, then we look obviously to special aspects. And the case law is very clear that special aspects are those that create an unreasonable risk of harm because they are unreasonably dangerous. And so the fact that it's dangerous, even in hindsight, does not satisfy the rule. It has to be unreasonably dangerous or effectively unavoidable. And if I'm reading the plaintiff's brief correctly, they refer only to the effectively unavoidable standard in their claim that this was a special aspect. The problem with that is that, and when you look at the photo, you can clearly see that this is a grid that this plaintiff could have stepped over. She could have stepped around. She could have not entered the ballroom if she honestly did not wish to confront it. Again, she knows that there are these grates around the room. So I think that just falls flat on its face. The plaintiff also argues that the hotel or my client had actual constructive notice of the condition, which that analysis only applies if in fact we get past the open and obvious. So we only get to notice because that goes to duty. And I think that there are a few points that are significant in relationship to that. The plaintiff admits that she admits that she doesn't know if that upturned edge was caused by her trip and fall or
But upturned edges at the hotel, was that a common problem?
The
upturned edges.
I don't know if it was a.
Well, they had that.
They definitely had that
and they
problem.
would go out and tape them down.
There were grids that were taped down, absolutely. And by the time they took Mr. Siddiqui's deposition, his testimony was that all of the grids in that ballroom had been taped.
They didn't go around looking for them.
They didn't go around looking for him, but certainly there were situations, obviously the room has to be cleaned, the room has to be set up, broken down, et cetera, et cetera. So certainly if there were employees or even guests who might complain that there's an upturned edge or some type of hazard, they would have come in, they would have reacted, and they would have taken, they would have repaired the issue.
Did he talk about how they discovered any of the previous upturned edges?
He did not. I don't think he was even asked that question. And what I can also tell you is that Mr. Siddiqui was new to that property when this incident occurred. I think he'd only been there. Do you remember how long he'd been there? He'd been there for a very short period of time. I know that. So I don't even know that he would have that information as it relates to why the other, or how the other ones were found, I think was what your question was. The plaintiff here admits that she does not know how long the upturned edge existed, even if it was present before she tripped and fell. She doesn't know what caused it to upturn, assuming that it was upturned before she tripped and fell, as opposed to she's the one who caused that situation to occur. I think it's also important to point out that the plaintiff, in arguing, misconstrues the testimony of Mr. Siddiqui. Mr. Siddiqui did not testify that the grids had to be taped down. In fact, he testified just the opposite. What he testified is what I just indicated to this court, is that if they were notified of an issue, they would come in and repair it, and it might be a replacement or it might be a tape down. So I just want to point out that inconsistency. The plaintiff has not presented any evidence, let alone sufficient evidence, that the defendant had notice of a hazardous condition, which again, we don't even reach if this case should be summarily dismissed on open and obvious. As a last Hail Mary play, the plaintiff argues that the restatement of torts should apply. But the restatement of torts is not an exception to the open and obvious rule. There's case law which supports that, which we outlined in our briefing. The plaintiff points to Riddle and Bertrand. Riddle was decided in 1992, Bertrand in 1995, and then we got Lugo in 2001. Lugo has been the law of this land, although the courts have carved some narrow exceptions with respect to the open and obvious rule, but Lugo, for the most part, is the law of the land in this area. And not only that, the illustrations that the plaintiff points to they don't really make sense. They point to the fact that, well, there was a potential distraction. Looking at the displayed goods,
It's
and
not
that's
our first open and obvious case.
Thank you.
I mean, pretty straightforward case. And
Thank you.
we've been doing this stuff for a long time, all three of us. So.
I sincerely request that this court reverse the trial court's order denying our motion for summary disposition and enter an order of dismissal if there are any questions, in addition to the ones I've been peppered with.
Go ahead. Well, since you're sincerely requesting it, we'll consider it.
Thank you.
And you do have a couple minutes left for rebuttal if you choose to use it.
Thank you.
Okay.
Good afternoon, Your Honors. Stephen Hardy on behalf of the plaintiff appellee. This is an open and obvious case, as Judge Murray just said. You've heard a lot of them. I'll try to keep it brief into my briefs and the points made. This is not your typical open and obvious case, as in nobody has testified here that they saw the defect. Many of the cases cited by defendant and many of the cases that are on point regarding open and obvious talk about the plaintiff saying they saw the defect and the defendant bringing up, well, if you saw it, why didn't you avoid it? That didn't happen here. It's the defendant's burden to show that either the plaintiff saw it or a reasonable person saw it or should have seen it. They don't have any testimony regarding that, any witnesses. All the people who came to the scene, well, no people came to the scene actually. So no one saw it. No one is here to say when the condition existed, when the plaintiff fell, that it was open and obvious, that someone saw it or someone
What
should
did
have
she
seen it.
testify as to why she didn't see this alleged defect?
She testified that it was a very crowded ballroom, that it was dimly lit, and there were chairs and tables all around.
So it wasn't that the square area melded in with the rest of the carpeting or anything like that. It was just too many people, tables and dimly lit, and I didn't look down, so I tripped on it.
She wasn't asked specifically regarding the differences in the color, but again, the differences in the color apply the objective standard. Could a reasonable person have seen that? And if the panel looks at those photos, you can see that they are very similar in color. It's gray on gray. And this is also a very small panel. It is 1.5 feet by 1.5 feet. The photo is very enlarged, just taken 1.5 feet away, zoomed in. You can see the lip that she testifies that caused her to fall is very small. It's only 1/4 or less of that edge. So we're talking maybe a couple inches here, something that you wouldn't see from across the room.
Well, she knew they were in the room.
Well, she knew the grates were in the room,
Right.
but all the other grates were taped over.
No, it's funny, and this doesn't apply to deciding the case, but I looked at one of the pictures of taped one, looked like it was a heck of a lot more dangerous than the one that she tipped, because it was raised more. The tape looked like it was raised up. Anyway,
Sure, Your Honor,
I think it's more dangerous after they taped, is my whole point.
and that kind of goes to the balances and what we weigh when we take these open and obvious cases on. That grid that's all taped probably is more dangerous, but it's way more readily seen, and you can see it from much further away. And maybe the duct tape is a little different when it causes a tripping hazard. And in fact, the safety engineer testified that the grid as it laid not being taped was an unsafe condition. And so just going back to it being the defendant's burden here, they haven't done that. They haven't produced their own pictures. They haven't produced any discovery evidence. There wasn't an incident report created by the hotel.
Well, she wants to use your client's testimony and basically says, we need nothing more. She's the one that says A, B, and C.
Well, it's funny, I wrote that down. I know the judge pointed that out when she was arguing as well, but the defendant here bounces back and forth whether we're going to use the plaintiff standard or the objective standard whenever it's convenient for them. The standard is clearly an objective person standard, and so it doesn't matter that the plaintiff didn't see it. But also the plaintiff wasn't specifically asked, were you looking down the entire time you were walking? And no one walks with their head affixed to the ground. We all have peripheral vision, especially when we're walking in a line to a buffet table. We're watching the person ahead of us so we don't bump into them. We're watching for chairs and stuff around us. We don't take one step, look down, oh, it's safe to go, take another step straight down.
Sounds like a Monty Python skit or something.
Exactly. And she testified there was a line going to the buffet table. So she's looking ahead. And, when you're in line, there's people's feet ahead of you that are obscuring how far you can see once you look ahead. And there's also tables and chairs and the lights being dim. It's all cumulatively as to why a reasonable person wouldn't have seen that defect in the floor. And the defendant cites all unpublished cases, and they're all distinguishable. That's all outlined in my brief. But there's
You know,
two,
that some of our colleagues have gotten very hot under the collar about citing unpublished cases. That I'm not one of them. That they aren't binding, but this seems to me to be the one area of the law where I can't blame the parties for citing unpublished cases because there aren't all that many published ones, and so many of them are fact specific that you trot out a unpublished and say, this is about the closest thing I can find to this. You people decided it. And it's based on these facts. That's just an aside. I mean, it's the end of the day. I keep my mouth shut. I end up saying things I regret around this time of day.
I do understand that, Your Honor, and I do go in my brief point by point with cases cited as to why they're not on point and why they're distinguishable. So I'm not going to go through all the cases, but there are two cases that are published that are on point. The Blackwell v. Franchi case, 318 Mich. App 573, and Price v. Kroger, 248 Mich. App 496. And the Price v. Kroger talks about a really small defect and very close to the ground. And the panel held that it was not open and obvious for those reasons. Same as here, very close to the ground, very small defect. And then when you take all the accumulation of the dim lights, the crowd, and no one seeing and testifying that was open and obvious and there to be seen, this should not be an open, obvious case. There's clearly a question of material fact when all the evidence is viewed in light most favorable to the plaintiff. In regards to defendant's argument about premise versus ordinary negligence, the lower court did not rule on that. The order from the lower court only talked about open and obvious and notice. So I don't need to address that here, I don't think, unless the panel wants me to.
I don't think so. You would admit it's not your strongest argument.
It's not my strongest argument, but I do cite a case, the Prebenda v. Tagalia case, that talks about, if they fail to exercise reasonable care, which the defendant's employee talked about should be taped down. I think it survives on that aspect as a question of material fact. And finally, we have the notice issue, which again, actual notice is not required. Constructive notice is fine. There's a plethora of case law that talks about how long a defect is on the premises is usually a question for a jury. In this case, we know that that was not taped like the safety engineer said it should be. And the defendant's in the control of the premises. All the other ones are taped. They have not said why that one was not taped, whether it was a new install, whether something had been
But
changed.
if the little piece of rubber wasn't sticking up like it was in the photo, then there wouldn't be any need to tape it, would there?
Well, the safety engineer said they should all be taped regardless. I asked, is this?
I thought he said not necessarily, but.
I think he did, and then he changed his opinion when I asked about the specific grate in question. And maybe we didn't go exactly into detail about whether it wasn't bent up or not, but all the other grates in the hotel are taped down. That was her testimony.
Oh, the inference there is that they must think it's a problem. Otherwise, they wouldn't be taping them down.
Exactly.
Or that they just were kicked up and then they taped them.
Well, the other, and again, judges, this is a question of material fact, it's what it sounds like to me, but he said every other one was taped down. So does every single one get kicked up every time? And if that's the case, then they should tape it down. And they're failing to do it. And I think the notice is very strong, and Judge Leslie Kim Smith didn't really go into it. I think the open and obvious is the one that had the most arguments. Again, defendant only cites one unpublished case regarding notice. All the published cases talk about constructive notice, usually a question for a jury. And so I'm asking the court to uphold and affirm the lower court's finding that question of fact exists for both open and obvious and notice.
Thank you. Well, no, you've got your right. You made your request for argument. You get some rebuttal. So
Thank you.
We did take up an awful lot of your allotted time. So I'm
Now,
sure it won't be long.
very briefly here. And I think this court actually hit it on the head. Mr. Sigway never said that all of the grids had to be taped down. What he said is that when by the time his deposition was taken, which it was sometime after this incident. I can't remember the exact time frame, but obviously we got a lawsuit and we got, some discovery going on. At that point in time, all of the grids had been taped down, and the only grids are in the ballroom. So it's not as if these are all over the hotel and we've got, a bunch of taped down grids across the hotel. So that is just not a fact. The second point being that there's absolutely no legal authority to support that someone has to see the defect before it's deemed to be open and obvious. I mean, talk about a third party. There's no legal authority for that. And we can show through the plaintiff's own testimony and the photograph which the plaintiff has presented herself with respect to why this is an open and obvious condition. The average person of ordinary intelligence, had they simply just perused the floor, would have seen it. She saw all the other ones. They were there to be seen. We believe that the case should have been dismissed. Thank you.
Well, again, another well-argued case, well briefed, and it will be submitted. So thank you both. Oops. That brings us to number 12, which is, I believe, a double case. For item 12, docket number 361623, the Dreeweer Shipley miners. It's consolidated with docket number 361626, Dreeweer miners. That will be submitted on briefs. 13, docket number 360711, the Able Miles Powell Stokes Thomas miners. That will be submitted on briefs. And finally, item number 14, docket number 361246, the PM Miller Kane miner. Submitted on briefs. That concludes our call. We are adjourned until tomorrow. Aye. Thank you.
I don't know if I saw you yesterday.